What can I do? Date is fixed, they will not come. Whenever they come,
Government advocate pointed out some materials do not 161 viral pen drive.
yes, get it. Have you got it?
नहीं sir. दे दे लेता.
Lease it tomorrow.
Pardon to Belgium matter will also be.
Give it, give.
Earlier I have given memo, my lord, CRPC 17/24.
Yes.
311 CRPC was rejected. The case is posted, my lord, to filed, my lord.
Nothing great is going to happen. Give it. We'll
So what happened, my lord?
give it. We'll
Pardon to mention, CRLMC for 3009 of 2019. Pleadings have been completed. What should we call it? My specific date has been fixed, but not yet come.
after vacation. 23 matters, man. This matter of 23 matter. The only recovery of money seized by item 23. No, sorry, man. The case is of the 23. My money has been seized, and the give the memo. Give the
Beg your pardon, my lord. I am on VC.
Page number 1, item 1 to 5. Page number 2, item 6 to 14.
Item 7.
yes.
And item 8 kindly not press, my lord.
Where is the memo? And you people are making statement. I am withdrawing, and you don't give the memo. I'll dismiss in the case you withdraw the case,
My lord,
and without giving memo. Subsequently, if I discover that memo is not filed, then I'll dismiss the petition with 5,000 rupees cost.
I'll file it today, my lord.
I don't know. I have told them. Wherever the memo doesn't come, you simply say that I'll give the memo subsequently. You don't give the memo. I have pointed out them. If the memo is not come, you dismiss it with the cost of 5,000. Write down that the I submitted that he wants to withdraw the petition. However, subsequently he has not given the memo. Dismiss the petition with the cost of 5,000. 7. Item 7. Adjourned? Yes. Item 8. Withdraw.
Item
Beg
10,
your
my
pardon,
lord.
my lord.
Item 10, my lord.
Yes.
In item 10, my lord, I will file a rejoinder. I will receive their counter, my lord. I will file a rejoinder.
Adjourned.
And your lordship may say the entry matter shall be continued.
No. Who is the other side?
Other side is a state, and another opposite party also, two is also there.
Why rejoined?
Your my lord, he has given the counter that I have to give a reply, my lord. It is necessary for the reply.
Mr. Rakadai, are you opposing or what? See, the once interim orders are passed, then
My
this
lord.
is the ploy, you know. I'll file this, I'll file that, and keep on adjourning the matter.
My lord, matter
That's the reason I don't pass the interim.
My lord, can one matter is reached, my lord, that by the time it's
We'll see.
Yes, yes.
Yes.
page 3, item 15 to 25.
Pardon your lordship. Lordship, item number 16 may be adjourned to 2 weeks after.
16, huh?
Yes, your lord.
Adjourned.
Page 4, item 26 to 39.
My lord, item 26.
Okay.
Take it up after vacation.
Yes, 26. Yeah.
Item 38, I think after vacation.
30.
38, 38.
Is there any?
No, please.
Okay.
Item 31, my lord, paying for after vacation.
31.
My lord.
Okay.
Obviously.
Page 5, item 40 to 53.
Lordship, item 49. In this case, appear for informant
40.
49. In this case, appear for informant advocate H.N. Mahapatra is out of station. So I pray for Lordship 2 more in this case.
For opposite party number 2.
Yes.
For opposite party.
I am the petitioner. For opposite party 2 is my learned senior advocate H.N. Mahapatra.
You want an adjournment?
Yes. Opposite party 2.
You talk about yourself. Don't talk about the others. Are you seeking adjournment?
Yes.
Yes, adjournment.
2 more, man.
Page 6, 54 to
Next year tomorrow. Yes.
54 to 68. Page 7, 69 to 82.
Yes.
Page 8, item 83 to 94.
Item 94, pray for after vacation.
94.
Yes, my lord.
Is there any interim order?
No, my lord.
No, okay, adjourn, okay. Yes, huh?
Item 94, notice could not be issued to non-filing of the petitions.
You have not filed the requisites. Notice was issued.
Yes, my lord.
Why have you not filed?
Today, my lord.
Don't adjourn, we'll see.
Page 9, item 95 to 105.
Item 102, your lordship. There are some defects and my learned senior is out of station.
Then comes for the petitioner seeks time to cure the defects.
Let it come after week.
Cure, yes,
100 also same.
100 also, cure defects.
Item number 105, 105,
100?
105.
Checking
for adjournment.
Defects not cured. 1 week time for curing defects. Yes.
Let's see. Item number 103 and 104. I want to withdraw them.
Withdraw. Memo,
I already.
withdraw.
Page 10,
Big-
item 106 to 119.
111 permit to withdraw.
111, huh?
Right.
1.
106 and 107, well. 106 and 1, I pay after waiting. No increment.
Fresh matters,
Yeah, no mid.
adjourn.
106 and 107.
Page 11, item 120 to
And
120.
the one which was withdrawn, 11.
111. 111, 104,
111,
103,
103, 104,
and 8 also.
Withdrawn, huh? Next,
108. Oh, khali at, huh?
8 also adjourn, huh?
No.
Withdrawn, madam.
Withdraw, madam.
Withdraw.
Only at 08.
Yes.
Page 10, item 106 to 119. Page 11, item 120 to 129.
Item 125. A compromise matter, wife was suffering from pneumonia for which any other day.
Adjourn.
Yes.
Item 126, madam. I am for the petitioner. They are not the 130 NI Act, my lord. I have to, the case has been filed in a particular place where it has not to be filed because the place of filing must be only where the check has been bounced. But my lord, I have to get some, I pay only next week.
Any interim order is
Yes,
there?
interim order is there. Next week only, Monday.
Notice was issued.
Notice is opposite party enter appearance last time also before this.
Let them come, let him come.
Sir,
Let him come,
all right,
126,
all right.
keep it, yes. Next,
Page 12, item 130 to 136.
Lordship, item number 134, my lord. The parties have personally appeared. Matter has been already settled. The OP number 2 has already appeared before the lordship, and her statement was recorded by this honorable court. 134, my lord. Petitioner sir personally present.
and are they here?
Yes, my lord.
12 o'clock.
Published.
Beg your pardon, my lord. Beg your pardon, I am on VC, my lord.
65.
My lord, I am on VC, item 135.
65.
145,
135, my lord.
yes.
The thing is, this matter was last time adjourned as it didn't reach. I think the
Yes.
same condition may appear here. If that is so, this matter may kindly be listed tomorrow. Because this is the matter, I can remind you, lordship, this is a matter where it is a covered matter. And it will take a very little.
It will reach today, wait.
Oblige, ma'am. Oblige,
Yes,
oblige,
fix.
ma'am. Oblige.
Compromise matter, my lord.
Fix.
Party just come.
12 o'clock,
Yes, 65.
yes. Any mentioning? Yes, any mentioning? Yes,
On criminal revision, sitting by 2024 fixed today, but not been listed.
give it to the chief. Yes. Yes, come on.
Item 1.
I may kindly permitted, my lord.
Yes.
Lords,
My lord,
if lordship permits, my lords, this is an application for condonation of delay, my lords. The registry has indicated delay of 1900. 1900 days delay, my lords. May I pray, my lord, friend, a spare copy
my
of
lord,
that petition.
my lord.
A spare copy of the petition.
My lord,
lords.
let me
revision is-
complete my submission,
Yes.
my lord. Actually,
A copy may be given to, that's all.
my lord, this matter was agitated before this honorable court in CRLMC number 734 and thereafter in CRLMC 110.
Hmm.
With the permission of this honorable court,
I have subsequently withdrawn the last revision, not CRLMC, revision. Honorable Court permitted me on 3rd April 2023, and that order is at page number 130 and 131. May kindly, your lordship may kindly have a glance to it. The order. Page number 130 and 131. At page number 131, this Honorable Court
Withdraw. You have withdrawn it.
withdrawn
Against the same impugn order.
Huh?
Against the same impugn order you had filed.
a fresh petition. Fresh petition against the same into.
Why
A
have you
better
withdrawn?
application.
Why have you withdrawn it?
I have withdrawn because some documents which are relevant for the purpose of adjudication of this case were not filed in the earlier petition. That was the whole reason. That is the reason. And moreover, with the permission of this Honorable Court, I have filed it just after 1 week. Although the delay starts from the very date of raising of the cause of action.
The liberty to file a better one.
Milords, may I submit, Milords, a copy of the spare copy was given to you and edit tomorrow. Let me go through the reasons there. You just describe how he was
The reason
prevented.
is.
Yes, Milord, I understand.
He says that in 2018, he has
Yes, but
filed the review.
I was coincidentally, I was the counsel at page 128, Milords.
Yes.
Annexure 9, Milords. I was the counsel, Milords, that permission, the criminal division are disposed of, Milords. 128, Annexure 9, Milords.
What is this revision is about?
My lord,
Against an order
How
that.
many revision you have filed? 3.
my lord, I am making it clear. First, I filed a discharge petition before the London trial court. That was rejected. Against that order, I came in division in criminal division number
Right.
734. And my lord, in that revision, an interim order was passed that in the event I file an application before the London court below, the London court below will grant me adjournment. But unfortunately, after the rejection of the discharge petition, the London trial court framed the charges. So automatically 734 become infructuous. So I filed another CRL criminal revision, that is 110 of 2018
Against the charge order.
against the charge.
To withdrawn it to file.
I withdrew it because some of the relevant documents are not filed.
What is the stage of the trial now?
The charge has been framed on 26/10/2017. If I stand
Yes,
correct.
thereafter what happened?
Milords, the trial, after the framing of charge, the trial begins. Milords.
That I know.
What is the stage? I will get instructions.
Get
And,
instruction.
my lord, I am making
And
it
a
clear.
spare copy of the
No,
petition.
no,
Milords.
I'm
See,
making
you
it
have been fighting against the charge order since 2017. We are 7 years has passed by now.
My lord,
By now, much water might have flown.
yes,
At this
yes,
stage,
my
why
lord.
should I interfere?
My grievance in this petition is very limited, my lord. I am making it
Grievance
very
is
clear.
charge?
One charge is for 13 to reduce section.
I want to know what is the stage of trial.
Stage of trial is till now, out of 21 witnesses, 10 witnesses have already been examined.
Much
On the
water.
list of the.
I'm filing the certified copy, my lord.
That's all right, but much water has flown. At this
my
stage,
lord.
what? Which charge you are challenging? Charge?
My lord,
Which charge?
my grievance is that when the matter was under investigation, I filed a detailed statement of accounts along with documents with the vigilance director, stating therein that these are my lawful sources of income. And that is at annexure.
It's all right. They have not taken into consideration.
Yes, they did
Now
not.
you
No.
Place it in the
My
trial.
lord, even the bank loans availed by me that were there in the affair for several lakhs, but they have not taken it in the charge sheet. And moreover, the documents which they seized during investigation that were relating to that bank loans that have been supplied to me, but in the charge sheet they have not taken into consideration.
Now you.
Now
you
I
need your
want that
defense.
let there be a further investigation.
Oh,
Let the charge sheet remain enforced. Let the examination.
Let the defense please be raised in the.
You
the
can
trials.
raise all these things in defense. You are not precluded to take.
No, my lord, when these lawful sources of income is already in the knowledge of the vigilance, so what is the fun of not investing into the same? My lord, I submitted the detailed report on 31st December 2010, and vigilance submitted the charge sheet in the London trial court on 15/11/2011. And the
I'll not incline to interfere in this stage at this stage because the evidence is at advanced.
My lord, at this, I may kindly permit only three months time I can be allowed to vigilance. Let them verify it because it is
3
admitted.
months time, I will allow to the trial court to become.
No, my lord, kindly allow 3 months time.
I can't accept everything at this stage.
But my lord, I am
You have
grossly
been filed.
prejudice. But what is to be proved by
Anyway.
vigilance? That is has been
Anyway,
proved.
any other ground you have?
That is the only ground that I have disclosed it before the vigilance. My lord, kindly have a glance to that is
The
annexer.
The petitioner in the present petition, in the present revision petition, petitioner is challenging the order dated 26/10/2017, whereby the trial court has framed the charges against the petitioner under section. Where is that order? Where is that order?
That is, my lord, that order is at page 124 and 125.
Frame the charges against the petitioner under section.
Directing to.
Where is the charge order? This is something else.
Charge order is 26/10/2017, page number 126 and 127. And the charge was framed when the
Section 13, 13(2), read with section 13(1) E of PC Act. So the grievance of the petitioner is that during the investigation, the petitioner had submitted many documents to explain the legitimate income of the petitioner, including the loan he had availed from the bank. However, the investigating agency, by ignoring each and every document submitted by the petitioner, proceeded to file the charge sheet. The charge sheet was filed on
15th November 2011.
15th November 2011.
Although it is dated 27th December.
Thereafter, the court below had taken cognizance of the offence. The petitioner moved an application under section 239 CRPC seeking discharge from the case. The said application was also turned down by the court below. Thereafter, the petitioner filed criminal revision petition 734 of 2017 before this court, which was also dismissed as infractious. Thereafter, the petitioner filed the criminal revision petition 110 of 2018. The said criminal revision petition, criminal revision 110 of 2018 was withdrawn by the petitioner on 3/4/2023 with the liberty to file a fresh one with better particulars. Subsequent to withdrawn of the said petition, the present revision petition is preferred by the petitioner on 10/4/2023. 10/4/2023. The petition is belated. Therefore, he has moved an application for condemnation of delay, explaining the manner in which he has prosecuted the present case.
The delay is 19
Present
hours.
case.
The registry has
responsible
indicated.
for the vigilance submitted that much water has now flown under breeze within these 7 years. Out of 29 charge sheeted witnesses, about 10 witnesses have already been examined, and the trial is proceeding at the expected pace.
No interference
at this stage is called for. I'm not inclined to entertain this petition at this stage in view of the fact that the charges were framed long back in the year 2017, and the trial has already proceeded. 10 witnesses have already examined. 10 witnesses have already been examined. However, suffice it to say that the trial court should do well to see that the trial is concluded as expeditiously as possible in view of the fact that the in view of the fact that the case, the present case pertaining to the year 2007, pertaining to APS case, pertaining to an FIR of 2007. FIR of 2000. With this observation, petition is equal. Next.
Item 2.
My lord, one more point, my lord. For the decision of the Honorable Apex Court in Dharmpal's case, even if some witness have been examined.
That's right.
Even if
I have passed the order. If you are agree, you know the remedy. Next.
Item 2.
Yes. Yes. What is this?
Who, my lord, the dispose of case. They have filed the case, my lord. Initial dispose of 6/2/2024. Again listed 9/4/2004, IA number 374 of 2004 for recalling the order dated 6/2/2024. What is the in order dispose of 9? Again, the file the same case, my lord.
We simply adjourn to August.
Right.
None appears.
Copy also not served.
Item 3.
In item 3, that I was submitting before your lordship that this will be settled, 138 matter.
Yes.
I'm praying your lordship, if your lordship is not inconvenienced.
And for the opposite party, there is no such instruction.
No, let me just clarify. Your lordship may take up on 28th.
What is the check amount?
Even otherwise, on my difficulty, I will pray for an adjournment. Your lordship, subject to discretion, can consider. So it's not that way.
1 minute, whether it is settled or not.
Let me tell your lordship that as an officer of the court, today morning I have taken instruction. It's almost at the final stage. My learned friend appearing for the opposite party may not have got the updated instruction.
Okay.
I'm only praying.
20th.
May I just
20th.
yes. 20th निहाले कौन होगा ना से आशिकी को affidavit file करी settle करिए.
All right, 20th.
यदि my friend wants,
you also seek instruction.
I will also.
There might be a communication.
I will also request my friend not to take it to a contesting case and encourage that settlement. Can I say settle କରୁଛନ୍ତି settle ହେଇଗଲେ ଭଲ.
You just seek instruction.
And if he doesn't pay, go to jail. Even if the conviction is confirmed, how does it help the other side, my lord?
Right. Next.
Item 4.
4.
May I please, my lords?
Yes.
My lords, earlier I had filed a written notes, small date check.
Right, it's for final disposal. And this case, my lords, an interim orders allowing him to take adjournment still continuing. The order dated 7.
I'll hear it after vacation only. It's not possible. Final hearing is not possible.
My lords, I will take only 5 minutes.
No, but 5 minutes he will take.
And important with our presence, my lord, this on court, my lords, right? Order dated 10/2/2020 directed me to obtain material instruction regarding the capacity of the father to donate a particular land to the petitioner, my lords, which is I pray for last opportunities, my lords.
Okay.
My lords may fix a date after vacation.
Adjournment.
And interim order to continue.
Interim order to continue.
Item 5.
5.
May I please, my lord?
Mm.
Last occasion, special messenger notice was issued and it was solved. I'm filing the service affidavit. It has already been solved, my lord. Service affidavit.
What is this matter is about?
Matter is arising out of matrimonial dispute. It has been settled, my lord.
498, 294, 326, 506, my lord.
They have
Divorce case allowed, my lord, wife taken money and did not appear, my lord.
Okay.
For that, my lord, issued.
Deputy service.
Service, my lord, another opportunity given. Somebody may appear, my lord, this case. Sufficient.
2023.
One opportunity was already given.
No, my lord. Not my lord. On 16/4/2004, my lord. Special message. Special message sub-person.
And earlier also this matter was listed.
My lord.
After taking enter the alimony is not No, interested to,
And notice served on the brother of the, the
on information of the,
opposite two.
as flag D.
Where are the accused persons?
My lord.
Where are the accused persons?
Accusation. Accusation.
No, no, no.
So release it on 20th. Bring the accused.
When
Service, affidavit of service is the affidavit of service on opposite party number 2 is filed on record. In the interest of justice, release the matter on 20th. Bring the accused. Yes.
Item 6.
May I please, your lordship? My humble prayer before this honorable court to set aside the order of 16/8/2021 passed by the London Additional Session Judge Devagowda. Passed the criminal revision case number 8/2021, and as also the order dated.
Yes, Mr. Rahul, you're supposed
My
to
lord.
take instruction.
My lord,
What
the
is this
instruction
matter?
has been obtained, my lord.
Huh?
The instruction has obtained, my lord.
Yes, what is this
At
matter?
the started of that, they humbly submitted that as per the confident statement of the petitioner and during the trial of the case.
Huh?
Trial is going on, my lord. And case before the Honorable Civil Judge come JMFC Remal for plea for release of the gun, my lord, was rejected. They humbly submitted that seized gun has kept in.
457.
Yeah, lordship.
Yes,
Of gun.
Yes, sir.
That is humbly submitted that the seized gun has kept in the Devagowda Armory by the memo number so and so. Officer Remala, my lord. And this petitioner has confessed himself, my lord, regarding that he has used that gun for the
What are the antecedents
antecedent, my lord.
involved in how?
No involved in the petitioner.
No antecedent.
Huh?
No involved in petitioner. Petitioner the gun use he करनी केवल धरथला जेहेतु तार surrounding of the area of the
Where is the FIR?
FIR.
Where is the FIR? You filed the FIR.
Your lordship.
What are the allegations against you?
Allegation ଯେହେତୁ ଜଙ୍ଗଲରେ ଘର କେବଳ ବନ୍ଧୁକ ଦେଇ ଯାଇଥିଲା ଏ ବନ୍ଧୁକର ମାନେ ଅଲଗା ଲୋକ ମାରିଛନ୍ତି ଏବଂ ବନ୍ଧୁକ କେବଳ ଆରି
Wild animal.
yes sir
Wild animal.
yes lordship on due of the delay of trial lordship grant the release on bail under section 52 of CRPC.
Yes, Mr.
My lord, 161 statement is there regarding the involvement of this petitioner, my lord. And that he has used the same weapon, my lord, that gun, my lord.
No,
which has been seized and I may be read that Bedavas Bera.
Bedavas ଆକୁ ମାରିଛନ୍ତି ଗୋପାଳ ନାୟକ one of the another person is ଦ୍ରୋଣ ବେହେରା ଏଇ ଦି ଜଣ ଆଜ୍ଞା ମାରିଛନ୍ତି.
They were armed. Anything seized from them?
Yes lordship no.
Then you went with the
ନାଇଁ ସେ କିନ୍ତୁ ତାଙ୍କୁ ସେ
my lord, allow me to read just 2 lines, my lord. He's saying right, my lord. ଆମ ଗ୍ରାମର ଦ୍ରୋଣ ବେହେରା ସ୍ୱୟଂସୋ ଶିକାର କରିବା ପାଇଁ ଆସିଥିଲୁ। ପ୍ରଥମେ ଶ୍ରୀ ଗୋପାଳ ନାୟକ ଓ ଦ୍ରୋଣ ବେହେରା ନିଜ ନିଜର ବନ୍ଧୁକ ଧରି ଆଉଳି ଜଙ୍ଗଲ ଆଡକୁ ଦୌଡୁଥିବା ଏକ ଦନ୍ତା ବାରହା ପଛରେ ଗୋଡାଇଥିଲେ। ଏହା ପରେ ଆମ୍ଭେମାନେ ଅଭୟ ସ୍ୱାଇଁ, ଭାତୁମାଝି, ଦୁଃଖବନ୍ଧୁ ସାହୁ ଓ ମୁଁ ନିଜ ନିଜର ବନ୍ଧୁକ ଧରି ବାରହାଟିକୁ ମାରିବା ପାଇଁ ଗୋଡାଇଥିଲୁ। ବାରହାଟି ଦୌଡିବା ସମୟରେ ପ୍ରଥମେ ଗୋଟିଏ ଗୁଳି ଫୁଟିଲା। ସେ ଗୁଳିଟି ଗୋପାଳ ନାୟକ ମାରିଥିଲା।
What is the stage? What is the stage of trial?
Now trial is going on, my lord.
At one point in time, the court has asked for a report from JMFC. What is the stage of the trial?
Trial is incomplete.
Incomplete must be incomplete.
The prosecution allegation dated 8/9/2019, near about 6 years.
Get the latest
instruction I may
lordship,
after, my lord.
lordship after vacation.
Lordship, kindly be dispose of any order will be passed. Kindly be dispose of any order will be passed. Will be speedy dispose of.
That may
Then I understand what is
6 time lordship instruction continuous.
I know, but you have to tell me what is the stage. You are the accused. You are also not.
No trial has been.
Whether charge has been framed or
no charge has been framed. No, only for No cognizency, 2019.
Cognizance नहीं है
He's not sure.
So not sure. So
You are also not sure. That's the whole difficulty. You should be sure about what you are saying.
RCP kindly be resolved. The speedy dispatch within 3 months.
Charge is not framed whether cognizance is taken or not. You don't know. 3 months. How many witnesses are there? You have not filed even a charge sheet. You have not filed even the copy of FIR. How would I know what is the allegation against you? You filed incomplete petition. Very good. Awaiting instruction.
Item 9.
Item 8, my lord. Item 8. Let's say, item 8, my lords, I filed the withdrawal.
Withdraw.
That cost part may be ignored, my lords. I have already complied. Lordship directed that if memo is not filed, my lords, cost, my lords, I have complied.
No, you filed the withdrawal. No. If you ask for a withdrawal and thereafter you don't file, then
Rightly, that should be the procedure, right?
Lord, in item number 9, my lord, your lordship at
9.
Your lordship at my lord.
On the previous date, my lord friend made a statement. The wife marriage has been divorced on a decree, divorce has been decreed on the ground of desertion. Taking into consideration, your lordship directed on the last occasion, in view of section 125(4), if a wife voluntarily deserted without any cause, she may not get any maintenance.
Right.
Therefore, your lordship directed on the other day that you take instruction for one-time settlement. But that statement is not correct. The decree of divorce has been granted on the ground of cruelty.
Not desertion.
Not on desertion. Even in desertion, I place some judgment. I will place some judgments. Even on desertion also, the wife is also entitled for the maintenance granted under 125. Here in this case, a divorce petition was filed by husband for grant of divorce to the wife, and that has been.
My lord, I will file a rejoinder, my lord.
10, yes.
My lord. Because if you file the counter, the opposite party number 2, so it need to be required, it need to be filed a rejoinder, my lord.
10.
My lord.
Who is appearing for the other side?
Other side, my counsel, the opposite partner was yesterday. Already I have taken the consent, my lord.
So, at the request of petitioner.
Yesterday I have already talked to my.
Then appears for opposite party number. Adjourn, interim order to continue. Yes.
Obliged, madam.
Item 11.
Application for discharge has been rejected, and your lordship has extensively dealt with the matter and passed the order on 2/5/2024. This is an application refusing to discharge after 12 years of the incident, my lord. In the meantime, he was not produced before the court. Co-accused persons have been released by facing trial, and the Honorable Supreme Court, in some other cases regarding this petitioner, has warned the police not to overreach their limitations.
Who is appearing for the opposite party?
Opposite state, state
one. Yes,
because he joined in Janmorcha, one after other 20 cases.
It will take little time, it seems.
Yes.
Long matter.
The sole point of argument of my learnings here is that sanction has not been closed. Can you see the subject to my submission and the verification of the order, previous order? No sanction has been taken at the time of taking cognizance. That is the whole submission made.
Right.
But my case is that sanction has already been taken. Then the rest part, many time will be taken. But some more time is required to be placed. But sanction is taken. That is a yes.
Sanction.
No case is there.
Sanction as per the rules, procedure provided, not sanction may not post sanction or something else. Because at this point,
that's it.
that is one
But
point.
that will not vitiate the entire trial.
Yes, entire trial. Entire. Your lordship has observed in Subhasri Das case, they have said that since the punishment is high, that is capital.
Okay, simply adjourn.
Yes.
Interim order to continue. Yes.
Item 12.
Let it come after vacation, my lord. This will come after vacation.
Well, my lord, I'm for the petition. The lordship on the last occasion, I must fairly submit. Your lordship on last occasion were not inclined. Now, my lord, I'm not going to press. I must fairly say. Now, my lord, my only thing is, my lord, your lordship had.
What is this matter? Oh, that.
This is matter wherein we had come against. They are agreed.
That defamation.
Yes, my lord, the defamation.
Yes.
Your lordship had opined that listen, your cause of action will only come if the Delhi court decides that their cases. My lord, may give me that liberty to.
Yes, of course,
my
sir.
lord, that's the only thing, my lord. I don't want it to be a res judicata. My lord,
Right. Then council, simply you will withdraw what?
No, my lord,
No,
I am the
that's
petitioner.
their petition.
He is the opposite
I'm
party.
the opposite party.
He addressed as a petitioner.
No, I'm sorry, madam. I apologize.
But I am
I'm
the
sorry.
petitioner.
That's
He is
it.
the opposite party, madam.
No,
Madam,
no, he has initiated the.
No, my lord.
defamation.
The
Yes,
peti-
You are agreed, you are challenging it.
Yes, my lord. Petitioner initiated one check bounce case at Delhi. His case, he initiated one CC case before the JMFC bonus.
Then I'll record a statement that you will withdraw the complaint before the court below, reserving your right to prosecute if cause of action.
My lord may not say I'll withdraw it because it's conducted by a local council there, my lord.
Then?
Because my lord may
Set aside.
my lord may, yes, my lord. My lord may set aside saying that it can be re-agitated after it's a
He
premature.
will get a stamp from the High Court, my lord, that you will initiate.
Yes,
It is wrong or right.
If suppose he is acquitted ultimately, and then.
But it is open. No more stamp is necessary. No certificate is necessary from High Court, my lord. Because the lower court will influence, my lord, the merits of the case.
No, my lord. My lord, the only
my
thing
lord,
is because I
basing
don't
upon-
want it to be a res judicata. Because my lord, if I am acquitted, my lord may kindly
Let me produce, my lord. My lord, the petitioner initiated the 138 NI Act case basing upon the Supreme Court judgment. Because a person who has committed offense under section 138 is a company. Each and every director is responsible. Accordingly, that, my lord, the petitioner added he is a director.
Right, I understand.
But that's why if he wants that the Honorable High Court should certify that after acquittal, he will initiate another proceeding. I pray only quashing of the cognizance.
This one, give it to me.
But at the last occasion also, your lordship wanted that please produce the initial statement and 202 inquiry.
Right, now,
That also I have.
Now he's not threatening further.
My lord, we're satisfied that we have got a case, but your lordship had said that you have a case before the Delhi High Court to say that 1cc.
That is nothing in this initial statement and
Now
202.
I'll pass you.
Grateful.
Order reserved, madam.
Yes.
Item 13.
I am appearing for the OP and I prefer let it come after vacation. And I have filed one petition.
I
am for the petitioner.
Yes.
I have come up against the inaction of the landed JFC Kantavanji.
He is seeking time.
No chance of that settlement is there for notice was also please to issue notice. The other side appeared.
Is there any chance of settlement?
No, say question, my lord, he has received some amounts.
No,
but,
not at all.
violating the section 56, he has used the check.
Settlement is possible or not?
I'll take instruction, my lord.
That's what I'm.
Yes, ma'am. Yes, ma'am. I'll take instruction.
Don't go into merit.
Yes, ma'am.
फाइल को तसना सुको छोटी वर्ग पीछे हो नहीं छोटी वर्ग
Counsel for the opposite party seeks time to get instruction from his client regarding the.
This is second round. Earlier also referred the matter to the
scope of settlement. Urgent.
Yes.
He has filed another application 482 to let it come along with that.
Give the number.
Yes. Yes.
Tag with that.
Yes.
Give the number.
Yes. He is to. My lord friend has filed, my lord.
Give the number.
Number has not come, but the D number has come, diary number. Yes.
Item 14.
Item 14, my lord. This is also a case where, my lord, settlement has already been done, my lord. But the whole difficulty is, my lord, the informant has not yet appeared. I am trying to get him, my lord. I can make his appearance before your lordship, my lord. Your lordship may call this matter after vacation so that in the meantime I'll get it.
Non-APS on behalf of police party number 2. Mr. Mishra, Learned Counsel for the petitioner submits that the matter is already settled and he will ensure the presence of opposite party number 2 on the next date of hearing.
Yep.
Leave the matter
They have already filed affidavits in the court below.
This is the matter. June, 20th June.
Item 15.
My lord, 15, this is watching of the entire proceeding.
Yes.
My lord, filed by the husband and in-laws.
Yes.
My lord, initially the marriage took place in 2007. They blessed with 2 daughters. They have been separated from the in-laws in 2013, and she left the husband's place in 2021. And thereafter filed the complaint case in 2022.
Yes.
And your lordship may kindly see, in spite of all these things,
Who is
she,
appearing for opposite party number 2? You are appearing.
I am appearing, sir.
and in spite of all this, your lordship may kindly turn to page annexure 3.
Is there any chance of settlement?
My
No,
lord.
your lordship.
Why?
Lordship, the allegations are grievous. If I may,
These are matrimonial dispute. What grievous?
Nothing.
no, sir. The allegations are grievous because this girl was pregnant. Her husband tried to kill her. In fact, the opposite party and her daughter, they both are very well present in this court.
My lord.
She has been tried to kill. She has been tried to be killed from life twice or thrice. Then what happened is she was pregnant and she was given some medicine so that she was bound to abort a child. So,
My lord,
matrimonial dispute
314.
is another.
314 has been deleted while filing the charge sheet. So the allegation found to be false.
See, if your husband is so bad, he doesn't deserve you.
Yes, my lordship.
Abandon her. Abandon him.
My lords, if the court may kindly look at a.
Settle it. See, the child's life is next.
That's only
My lord,
one-
may kindly fix the
In
date.
this matter, already one CRLMC has been disposed of. So I
No,
can
my
only
lord,
see that.
My lord, may kindly say,
Now, is it so that you have given declaration?
I already declared. But that is at the time of trial, I raise all this issue. This is only the court considered this much.
In the CRLMC petition, that certificate is not there.
Certificate is there after removal of defects, all these things tag with this.
Only you are given liberty to raise all these points before trial court.
My lord, since the in-laws age about 79 and 80 years, my lord, and they are unable to move from Bhubaneswar to Sambalpur.
But how will you get over this order?
My lord, this is not the this is only a direction by this honorable court that at the time of trial I raised all this issue.
You
But
have to raise those
but
issues.
my lord, the final charges have not been filed by the police till yet. Since 2017 to 2024, this matter is pending before the SDGM. And the in-laws are now 79 and 80 years old, my lord. And they are unable to move from Bhubaneswar to Sambalpur. That's why I pray before this honorable court to question the affair of in-laws and the husband, my lord.
They were the petitioners there, Mahendra Kumar.
Mahendra Kumar, in-laws.
You yourself have filed. That's the problem. Where have you given the declaration about this?
I at the time of defect of removal of defect, I filed all this
Where is that?
document.
This order is in 2023.
Your Lord.
How will you get over this order? 2023, immediately you are filing the petition.
But my lord, because of all this.
What? Because of the same thing was there in the 2023 also. How can I ignore the order of a coordinate bench?
But my lord, the age of the.
Age 23, what was age? 2023.
But because it is differ from council to council.
Within
and
1
it is-
month.
My lord, because he is suffering from different type of disease also.
But
Yes.
all these things were available when this matter was taken up by the coordinate bench. You should have highlighted those things. You obtain an order. against you.
Previously, I do not have any knowledge that he filed a previous this type of petition before this honorable court. After
I can't entertain because see, because of that order, I can't entertain. I have all sympathy for you because you are very old, but there is an order of coordinate bench. What can I do? The coordinate bench has given you liberty to go to the court below.
But my lord, may kindly say till yet there is nothing any filed by the police. Final charges had not been filed by the police, my lord.
Madam, see,
And,
where is your earlier petition? What are you challenging here? To quash the FIR.
Quash the FIR.
There also you have done the same thing.
But whether all these things available in that record or not,
How do I know? You have filed the your own petition. Give that order. Take. You have that order with you.
My lord, I filed this order from download by the.
You have this order with you.
My lord, only the order is with me,
Oh.
but the petition is not available with me.
It is
And
your
but-
petition. Shall I get it from somewhere? Please the matter. Get the file up for this. 3567 tomorrow. If you have asked for the same thing in that petition, then this has to be dismissed. Yes.
But my lord, may kindly see this now the petition is for Mahendra Kumar and Srimati Sunanda Pradhan.
I need to know you don't
Marat.
know anything.
Marat.
Yes. Tomorrow. Along with call for the file, huh? Call for the file. Let me see.
Item 18.
Quashing of criminal proceeding under the ground of settlement, my lord, between the parties. Both parties are present, my lord.
Present.
Petitioner and informant and victim, my lord.
Yes, Mr. Gada.
I'm appearing and I have filed the joint affidavit.
Yes.
Worship, on the earlier occasion, the opposite party number 2, the informant appeared before this honorable court. She has also voluntarily stated that she doesn't want to proceed further in this case. It's a matrimonial dispute, lordship.
Her presence was dispensed with.
Yes, my lord.
Where is that? Which order?
Informant opposite party number 2. That was listed on 7th, lordship, 7th of May.
But her presence is not dispensed with.
She has voluntarily stated before lordship that she does not want to proceed further in connection with this case.
Divorce is granted.
Yes, my lord.
Where is that? Judgment.
Yes. I have annexed the same.
Right, on the matter was taken up for hearing on 7/5/2024. On the the petitioners are present in court, represented by the respective counsel and guided by the so. Where is the affidavit? You have filed affidavit? Affidavit upon
No, my lord, no separate affidavit has been filed. my lord.
The counsel for the petitioner submits that the marriage between petitioner and marriage between petitioner number one,
Yes, my lord. Petition number
one and opposite party number two has already been dissolved by an order dated. Which order? Order dated 9/9/2020.
Yes, my lord. 9/9/2020.
9/9/20 passed by family judge, family court Bhubaneswar in CP number 614 of 2018. You have paid permanent alimony and all?
Yes, my lord.
Uh,
7 lakhs.
In the
7 lakhs.
In the divorce proceeding, the parties had also filed a joint affidavit, filed a joint affidavit, filed a separate affidavit for compromise, which was taken into consideration and marriage was dissolved. The petitioners have paid rupees 7 lakh rupees, rupees 7 lakhs to the opposite party number two towards the permanent element. The compromise petition filed by the petitioner before the court below are part of record, part of the record, which is placed as an Excel 3. The opposite party number two had appeared before this court on 7/5/2024 and has stated that she is after the settlement. Their marriage has already been her marriage has already been dissolved. Therefore, she is not interested to proceed with the petitioner anymore. Mr. Maharaja appears for the state and submits that since the dispute is essentially matrimonial in nature and the parties have settled their dispute, there is no legal impediment in pursuing the file. Taking into consideration Gyan Singh and P.C. Joshi. Yes. Next.
37.
97.
Where is that?
37.
Where is
97,
that lady?
9.
Complaint is the opposite party number two. Let me do so within 1 week. Adjourn. Yes. Next.
21.
That may be fixed, my sir.
Date he'll fix it.
Gentlemen, not press, my lord.
Not press. Not press.
Memo.
Memo. Give the memo. Yes. 22.
22.
I'm on which my lord permitted to. Sir. And this present petitioner, he was attending the court regularly before the lower court. When the case was posted for request statement that is on 28/6/22.
Yes.
Because of his absence, a warrant was issued.
Warrant? Where is that?
28/6/22.
Yes, my lord. Annexure 4 may kindly be seen.
Annexure 4 is the warrant.
Yeah, the order of the lower court.
You are on bail.
Yes, my lord. He was on bail since 2016. He was regularly appearing.
Right.
Only
It's
after-
all right. All right. Petitioner is making the so case due to his default in appearing in the court on what is the date? 28/6/2022. NBW against him has been issued. Mr. Murthy, learned counsel for the petitioner, submits that his client would appear on or before 30th of June.
Yes, my lord.
30th June, and avail the remedy under law, subject to how much cost you will pay to the bar? 500.
As your lordship directs.
Subject to petitioner paying rupees 500 as a cost to the bar and appearing before the court on or before 30th of June 2024. The NBW issued by the Court of Additional Sessions Koraput in city case number 70 of 2013 on 28/6/2022 is set aside. Yes.
23.
Is good.
Much obliged, my lord.
Yes.
23, my lord. Yes, for the personal proceeding of the ground of compromise, my lord. The affidavit is also true. I think after vacation that will fix.
After vacation, yes.
Notice and notice and notice.
Notice.
Notice you notice.
Notice issue notice, huh? The opposite party. 24, na?
24 now.
Item 24, you are appearing.
24.
23. 1 minute, 23 has he impleted? That's the problem.
23 yes, sir.
Yes, impleted.
OP2.
Opposite party.
OP2.
Yes.
You should notice.
Next, yes.
And no course of action will be taken in the meantime.
No. We should notice, right?
24.
24, I am appearing on behalf of the informant. I have filed an IA 506 of 24. So that may be allowed.
You are the petitioner.
My lord. I'm the petitioner.
24.
Yes.
Yes, he is the opposite party.
My lord.
Yes.
I was not made a party. Therefore, I have come up by way of intervention. Filing the
Intervention is allowed.
My lord.
Application IA number
506 of 2024.
506 of 2024. Moved by the opposite. Moved by the
Intervener.
Moved by you are the informant.
I am an informant.
Informant. Informant. In which case in FIR number so and so is allowed, and he has, and the informant is made implemented as opposite party number 2. Yes. Next.
My lord, here my lord, I have filed an IA, my lord, for stay up for further proceeding in the lower court.
You satisfy me on merits, then the IA will come. What is this case is about?
The
Framing of charges.
yes, my lord.
File revision.
That's already time.
You would file a revision.
That will be after vacation.
August.
27.
My lord. Here I filing the application for challenging the order of cognizance. In the meantime, my lord, other 4 accused are already faced trial and acquitted. And against the present petition, the individual is there, my lord.
You must be absconding.
My lord.
You must be absconding.
My lord.
I'll then
That order is, my lord.
set aside the
Warrant, my lord.
NBW.
My lord.
Right. NBW order.
Dated 36/18, my lord. 36/6/2018.
The petitioner is then accused in an FIR number so and so. Charge sheet was filed. However, the petitioner was absconding.
2 persons.
Petitioners were absconding.
My lord.
Therefore, insofar as the other accused persons, other 4 accused persons, those who were apprehended by the police, face the trial by order dated, by judgment dated 16/10/2020. The additional sessions judge Kurda in ST case number 90 of 2018 has recorded an acquittal in favor of them. In favor of them. Since the since the petitioners were the present petitioners were absconding, the court below by the order dated 3C/2018 has issued NBW against the petitioner. Therefore, the petitioner seeks indemnity. On instruction, the counsel for the petitioner submits that the petitioners would be appearing before court on 30th of on or before 30th of so and seek appropriate remedy available to them under law. Taking into consideration the aforementioned submission, the NBW issued by the
Learned JMFC.
James Tangi in
GR number 72/18.
In GR case number 72 of 2018 on 30C is set aside, subject to the condition that the petitioners shall appear before the court on the control and they will be determined. Yes. Yes, next.
28.
May I please your lordship?
Lordship, the petitioner challenging the cognizance order dated 23/9/17 and the NPW order dated 6/5/23. Lordship, the informant I have opposite party number 2 I have make party, and there is a compromise between the petitioner and the informant, which is annexure 4, page 16 to
What are the offences?
offenses under section 498A, 304B, 306, 406 of IPC.
Present dispute is arising out of a matrimonial dispute, and then comes for the petition submits that the parties have settled their dispute, issue notice, written proof.
No question.
In the meantime, the NBW issued against the petitioner.
What happened, my lord? Actually, 307 for 304B.
NBW stay for NBW issued by the court of JMFC Tirtol, by its order dated 6/5/2023, execution of NBW is stayed till next year. Yes.
29.
The second round litigation of the present petitioner, my lord. So the petitioner filed a 127 petition before the London Family Judge since 2023, my lord. In spite of the direction of this honorable court.
Issue notice to opposite parties.
Yes.
Have issued notice. It is a maintenance matter.
Maintenance matter, my lord. The wife has already remarried, my lord, since 2019.
I'm issuing notice. Let us see. Let them come forward. Yes. Yes.
30.
Three opposite parties are there.
You file the requisition.
My lord,
Yes.
challenging order of cognizance under annexure 2.
But
what happened? The factual. But charge sheet has not been filed, my lord. Charge sheet mu arrest kori feta korchi cognizance order for challenge sir. Cognizance kare I'm janing
let it count for the seeks an adjournment to file additional document to substantiate its case. Urgent.
My lord, only simple, my lord. The case is that.
Not whatever case, where is charge sheet? How will I test the cognizance order without charge sheet? That's minimum. Charge sheet, cognizance is taken on FIR or charge sheet?
Okay, my lord, I will.
That's minimum.
32.
Develop the practice of filing full all the documents. Yes.
32.
My lord,
I'm appearing through BC, man. I may pardon my lord, I'm appearing through BC.
File charge.
See, he will give the date. This is matter impossible. It is not reaching. What to do? 150 matters. You have wasted time. You should have come with the full preparation. What to do? Yes, next.
32.
Yes. I'm appearing through BC. I may pardon my lord. This is a case where I have challenged the order of cognizance taken by the SGM Bhubaneswar under section 289 of the IPC. On the ground, while the allegations is, my lord, that the petitioner has a dog, my lord. They have a dog, my lord. On the date of occurrence, the dog was playing with another boy, neighboring boy, my lord. And the dog, it is alleged that the dog bite the boy, my lord, for which a FIR was lodged, that due to the carelessness of the owner, the petitioners, the dog bite for which, my lord, FIR was lodged, case was registered, and charge sheet was filed under section 289, my lord. So my respectful submission, my lord, there is absolutely no allegations of any carelessness, nothing, my lord. And 289 is not attracted. And one thing I want to point out, my lord, I do not know the practice, of course. This case was earlier filed, my lord, by this honorable court, challenging the FIR for passing of FIR. It was dismissed by another bench, my lord. Probably there is no bar to move your lordship, but I must point out that this is the past of this. This is the history of this case.
I'll just issue notice. Let us see.
As your lordship. As your lordship, please.
Is it dog bite and all small?
Yes, ma'am. Yes, ma'am. Small case and neighbor. There is chance of compromise also we are trying. And no issue of a bail. No issue of a bail also. They were released under 41.
Yes. I just issue notice. Let us see. Let them come. Exactly. Small issue. Yes. Next.
Stay, my lord. Stay, my lord. Stay, my lord. Otherwise, he will proceed, my lord, with witnesses.
You are on bail. What? Nothing is going to happen.
If the case will be tried, my lord.
You are already in bail.
Yes, my lord. Bail, and there is no problem for me. I am on bail, my lord.
May say time. They will 5% there.
Yes,
Mr. Naik, the counsel for the petitioner submits that he would move appropriate application before the court below for seeking adjournment owing to the fact that the matter is sub judice before this court. Yes.
33. My lordship.
Yes.
Lordship kindly pass over this item.
No pass urgent. Urgent. Yes.
Yes, senior,
30,
another
30,
person.
34.
People, my lord. Last
Yes.
package of the lordship. Basing on the commission report, there is no case against this plan.
Yes.
In fact, my lord, I got the file, my lord, though the case record was in the year 96, my lord. But in fact, my lord, some of the accused persons are arrested, my lord. These petitions, my lord, both the petitions, my lord, they have absconded and charge sheets submitted evidence showing them absconded, my lord.
No, that's
Even
right.
if they have got the report, my lord, in fact, my lord, they are involved in this case, my lord, leakage of
Your
coaching
lordship,
papers, my
the
lord.
lordship may see the commission report.
Nice.
Complex by the, you know, 6 months maximum punishment.
1996
Yes.
case.
My lord.
Sentence is only 6 months.
Yes.
My lord,
There is a commission report,
Yes.
they are not
That-
involved.
yes.
But in fact,
Directly,
charge sheet has been submitted, my lord.
Yeah.
Which one will believe?
That's
which
why I
one
have
disbelieve, my lord. If she believe the commission report, my lord, then charge sheet, my lord. Charge sheet submitted by the competent authority, my lord, with the competent officer.
What
my lord.
about the trial of other?
But for that
Your
report.
lordship, that report has come, your lordship last occasion has gone through that.
Two
And
reports
also shown us
one
nothing.
from the GMFC and another is the SG.
647. 2007 ରୁ କୌଣସି ଡେଟ୍ ବି ହଉନଥିଲା।
abscond ରାଗନାର କେମିତି ହବ?
କାହାରି ବି ଡେଟ୍
Today ମାନେ
ହଉନଥିଲା।
they have
Proceeding
absconded.
was closed।
ତାଙ୍କ ନା ଲଗା, କେମିତି abscond ଅଛନ୍ତି? Split of health ହବ?
The only thing is, the people, those who are suffering the trial, if I quash, it will have a direct impact on them. That is the problem.
Exactly.
But what
Otherwise, you have a case.
My lord, on inquiry.
See, I'll tell you. The people, those who have been apprehended, they have undergone the rigors of the procedure.
They're involved because
Wait a minute,
yes,
the rigors of the procedure.
my lord.
And you have avoided somehow.
My lord.
And you are going to take the advantage of
This
your own
commission
wrong,
report. Yes.
own wrong.
Yes.
Whereas the other people, those who have really participated, they are suffering.
Your lordship may see,
Exactly.
lordship, I am just pressing. The informant himself became accused in the charge sheet, your lordship may see. Became accused. Informant himself. And
he has involved, my lord. He is instance, informant
yeah.
instance, my
Your
lord.
lordship may see.
Who all are facing trial? How many accused persons?
Last occasion, your lordship directed to produce the same before your lordship because
report मागायला.
So
14% charge after submission of charge sheet, my lord, prosecution.
there are 14 people.
Against my lord, against 5 persons, they are shown as absconded and individual issued against them, my lord. That
Out
is
of
when-
14. Out of 14.
My lord.
9 people are facing trial.
My lord. Whether all of them appear before the court after my lord getting bail.
The problem, see, the report is not also clear.
But the moment my lord, this case will cost my lord,
Report
they
your
will
lordship.
benefit from this, my lord.
So then I am interfering in the trial of
You
those
lords may
cases.
direct, you lords may direct them, this
That's the
petition, my
problem.
lord. My lord, they quash the NBW and direct them to appear before the court, my lord, target the case, my lord. So that it will be disposable within a short time, my lord.
The commission has
My
clearly
lord, absconded,
stated.
my lord.
My lord,
How the court
like
will
us,
accept
we
the
are
commission report
directly-
and
I'll tell you, the commissioner report is in your favor.
Yes, my lord.
Case is of 1996.
Yes, my lord.
Total sentence is 6 years.
6 months.
6 months.
Yes, sir.
These are the very, very strong point for the question.
Yes,
This is one thing.
Yes.
What is against you? You are absconder. First. Second is the other people, 9 people, those who are facing trial in the same case. If I say anything on merit, it will have a direct impact on this. And the people, those who have suffered the trial, they are in a disadvantaged position. You absconded, you are taking advantage of
If
your
I am absconded, I am continuing in service. That is their plea to file the charge sheet showing us the absconded, my lord. We are continuing in service.
You know the
Yeah.
commissioner report, but you don't know a single paper, whatever against you, you don't know.
And the commission has said that you have directly or indirectly, you have no. Your
How
lordship,
How to
the leakage of question paper, we are least concerned. my
the
lord.
problem, another problem is what is the stage? Nobody knows. Trial.
4/7/2024. That is fixed because your lordship's direction is the Law and Court Bureau has given the letter showing that date is fixed for 4/7/2024.
So High Court, Court of connection with clear cases.
That's happening.
Case record of clear cases issued from production of the accused person.
These persons, my lord, these persons, Rajkishore Naik, Bhajendra, and two persons, Muralidhar Singh and Sarveswar, my lord. But 4 persons absconded. 2 of them came forward here, my lord, came here and filed the application. And other 2 are not there, my lord.
All these things are very
significant. Nothing against, my lord, when the commission report come up, so what remains against?
Show me one thing
My lord.
from the record that you are working where?
Yes, my lord. Lordship may see in the commission report, page 42.
Not commission report. You tell me.
Police
Commission has examined, my lord, because the records, Lordship may see page 403. Your lordship, say paragraph ta dekho to sei thare lekha
That I read.
Ha, no, next elaboration is there. 406.
Sir, commission report ko nahi to acquittal pass kari honi na. That has to be again tested. What is the worth of it?
Page 406.
I'll ask for a very detailed report from the
Yes.
court below.
Yes.
It's not coming clear.
Yes.
Yes.
Also
my lord, commission report for learning page 23.
I know that.
Categorically, he has stated.
That I
Dekho.
Although the learned court of JMFC cognizance taking court might report dated 4/5/2024 submitted a report before this court. However, the same report is from the same report. However, in the same report, detail of the case is not. I can't say anything against the magistrate also. Whatever was asked, he has given.
Well, had not been mentioned. Had not been mentioned. The same be reflected.
It will later, your lordship may call for the photocopy of the, my lord, the scan copy of the LCR, my lord. Everything will happen there. Scan copy of the LCR will there.
Since
Scan copy.
Although the JMC have submitted report wise also, but detail of the case is not revealing from the said report. Therefore, the JMFC is also directed to
send the scan copy of the
entire proceeding of the court below by the next date of hearing, least the matter on 20th of June, first table.
Yeah.
Till then, no corrective
but you have to participate.
Yes, I will participate. No corrective action. Because warrant has been.
Right on.
I will participate in
till then. No coercive action shall be taken against the petitioner, subject to condition that the petitioner
in the proceeding.
Subject to condition that the petitioner shall appear before the court or appear oblique surrender before the court below and seek remedy.
In which court they will appear, my lord?
JMFC.
No, my lord. Their file can't go to JMFC, my lord. Those accused persons appear, their file one split up and go to the JMFC to cognizance.
Wherever I'm appear before the court of JMFC to cognizance because it's a bailable office. Let them at least appear.
Yes, ma'am.
Appear and
Obligatory.
you appear and
yes,
you are protected. No
yes,
coercive.
Lordship, I have skipped 33.
Already adjourned, it seems. Adjourned? Yes.
Lordship, but here the problem. It's a very simple matter. This is very
simple, but you are not there to urgent what to do. See, we are reaching at 1 o'clock. Only 33, 130 meters up there.
35.
Next date, I will take it up. Don't worry. Is it very urgent matter?
No,
no urgent.
Not at all urgent.
No urgent then. Yes.
35 kindly adjourn next week.
34.
35.
35 urgent.
36.
Yes.
May I please, Your Lords. Sir, my lord, I am challenging the Annexure 3, the order of the learned magistrate, wherein a old man of 72 years has made a complaint about his humiliation and manhandling before the police authority, and the same has not been taken care of, for which I have filed one 1cc case. Then, my lord, it is at Annexure 1. So, under Annexure 2, inquiry was conducted in 202, and that report is there. Finally, when the matter was taken up on 29/11/2023, ignoring all these inquiry report and evidences, the same was dismissed. The complaint case was dismissed. Against that order, I came up before your lords.
You are the complainant.
I am the complainant. I am aged about 72 years. And while I was on the road for walking in the morning walk, so these 5 persons, those who have threatened me and scolded me in filthy languages that I have totally narrated in my FR as well as in the complaint case. Despite of
They have beaten you? No.
No,
Only
they have not
scolded.
beaten, scolded and threatened
You
me.
are 71 year man, you learn to forget people.
I've tried my level best. Despite of my father figure age, still then I have been humiliated like
I
anything.
think these accused persons are young people.
They're not young. They are in fact in the guise of, I mean to say, journalist card. They have done something which is detrimental for the interest of the society. That I have raised. In
But
fact,
you should be above board. You are 71 years.
no, I do concede to that action, but
Yes.
why is the same for all?
Just forget them. The
No,
offense is-
forget and forgive is the concept.
But
That should,
see-
but at the same time, kind of a glance to page 15. Admittedly, what the eyewitnesses.
That's there.
So it cannot be dismissed like this when the very documents is there, narratives are there by the accused.
So let us see, issue notice.
Aye.
Issue notice. But you should forget small things.
Aye, keeping in view my age, but I have been humiliated like anything because I am a local inhabitant. So it is very difficult and
Okay,
it
let
is
us-
painful that I cannot ascribe before your lordship also.
Let us see, let them come. Yes.
And returnable data after vacation.
Only difference there, 202 statement and by initial statement before the court has become different. Only.
Pardon, my lord, item 34, your lordship directed subject to condition to surrender, the date may be fixed, otherwise your lordship protected, they will not surrender.
Within 15 days.
Yes.
Within 15, surrender
Yes.
within 15 days.
Yes.
Yes.
Problem.
37.
37, my lord. The petitioner file this case for quashing of criminal proceeding against the petitioners, my lord. Under section 376D and 506, my lord. The fact of the case is that the
My
husband
lord,
of,
376D, my lord.
but till that charge sheet.
Yeah, okay.
So then why charge investigation is going on? Why have you come now?
Not, charges are not filed.
That's what I'm saying. Investigation is going on.
Till 5 years has been elapsed, my lord.
You must be absconding.
No, my lord.
Are you on bail?
I'm
No,
saying.
no, my lord.
No,
Earlier he has applied the
petition-
bail 12,000 on which has been disbursed of 10/11/2023. Cut the clock. Just
The file on this court, my lord.
yes, I think that is bail has not been granted.
Not till that bail is not granted, not absconding, and petitioner 1 is the retired high school teacher, my lord. Petitioner 2 is a practicing judge.
What are the allegations against you?
Allegation is, my lord, the informant opened the door at 12 a.m. and saw 5 persons are standing, out of which 3 persons present petitioner, my lord. Petitioner was raped her and petitioner 2 enter her private organ and then he shouted and thereafter one Ramanath Barik and her husband
14 years girl only.
Taken to hospital, then hospital forward to police station. Thereafter she came to her house.
My lord, I have to take the instruction, my lord. Let us-
Gang rape case.
Yes, my lord.
26.
After vacation, charge sheet they will file. Thereafter you file fresh petition. I have given that leave.
No, no, my lord.
Yes.
No, my lord.
Yes. Next, 39. huh?
May I please, your lordship? Last occasion, lordship directed to appear the petitioner in the opposite party. The petitioner appeared and he contacted. He contacted the opposite party number 2, who's supposed to be the wife of the petitioner, and she is residing at Bargarh, for which she is unable to.
Last date I have not said anything.
That is.
As requested, is the matter.
Item number 39.
39.
Because the matter is already amicable settlement for questioning of the entire criminal proceeding.
But where are they? You have to bring them, we settle.
The husband is, the petitioner is appeared before your lordship, and he contacted the opposite party number 2.
What can I do, sir? It is
So lordship
498.
kindly taken on after vacation.
You bring it, it is 498 and all. You bring
Yes.
your wife, you are separated.
Separated.
Applied for divorce.
Not applied, they are executed Khula Nama because they are Khula Nama because they are belongs to Muslim community. They are executing Khula Nama. For which
So bring her.
bring her. Obliged to Lord.
40.
May I please?
Yes, ma'am.
My lord, due to personal difficulties, the day after tomorrow also.
Adjust.
41.
May I please, your lordship? My lord, I have challenged the cognizance order, but I am sorry to submit, my lord. Let it come after vacation. I will file the charge sheet, my lord.
Let the counsel seeks an adjournment to file additional document to substantiate the case adjourned. Yes.
42.
42, your lordship may please be allowed. Item 42. But here the informant is before your lordship. But straightway I draw your lordship attention to annexure 4. Here, through a MOU, 1 crore was supposed to be received by the private opposite parties. They have received 30 lakhs, but not delivered the land for which the MOU was executed. Later on, they cancelled the MOU. I filed the complaint case. It was registered as FIR. And this honorable court, while granting anticipatory bail, that is page 33, annexure 4, passed the order that upon deposit of the entire amount with accrued interest, they be released on bail, my lord. Now, here the informant who is suffering because the money is there tagged, my lord, deposited in the court. I have approached the court with a prayer that let the money be disbursed in favor of me, giving property security. That has been rejected. CRL MC was carried. So under the circumstances, what I pray, my lord.
You are for the informant.
Yes, my lord. So speedy trial is the speedy trial.
Accused got this bail.
Yes, yes. There, the question not pertains to that. Question pertains to speedy trial, madam. What I humbly pray, I have added them as opposite party number 2, 3, 4.
Now you got a decree now.
They got a
Money
decree.
decree.
I have got
money
a
decree in the bail
But it's
petition.
not
You got a
writing.
money decree.
It's not writing. It is only hanging in the tree. I can see, but I can taste.
Even if you get a civil decree, the same thing happens. Now it is a kind of a money decree.
Under the circumstances, what I pray, opposite party number 2, 3, 4, let me take notice through special messenger to them.
Notice.
Through special messenger, I will deposit the cost by tomorrow.
Through special messenger. Issue notice, to opposite party number 2, 3, and 4.
And if required, I will serve extra copy to my own friend.
Yes, definitely do that.
Grateful,
Yes.
Your Lord.
Item 43, your lordship, can be taken after recess, your lordship.
No, you tell me why recess?
The file is not with me.
Huh?
File is not
Well,
with
then
me with the message.
after vacation.
Your lordship,
After
kindly.
full recess of 1 month. Yes.
On Monday, your lordship, kindly come.
And possible.
Matter will going to settle, your lordship. So
Oh, you settle, then you mention it. You bring them and mention. I'll take it out.
Just
next.
Item number 43.
44.
just to go to pass over
44.
Also not possible. 130
at 2 p.m. your lordship.
Yes.
44.
Obliged.
44. Yes. Display board.
Journalist hour. 34, 544. Nobody, not.
44, nobody is there. None appears in the interception. Yes.
45.
May it please your lordship.
Yes.
We have challenged the criminal proceeding. In the meantime, the final form dated 30/3/24 case is closed as there is no evidence against accused petitioner.
Sorry, I didn't follow you.
My lord, I am audible, my lord.
Yes, I can hear.
My lord, final form dated 30/3/24 is filed and the case closed as there is no evidence against the accused petitioners.
Who are you?
My lord, I am Aishwarya Swai. Appellant. I am for the appellant.
The appellant, but you are accused or what? You are
Accused, my
accused.
lord. Yes,
Then
my lord. I am the accused.
What is your grievance? If the final form is filed, and you should be happy.
My lord, there is no case against me.
That is why the police has filed closure report.
Yes, my lord.
Then why have you filed this petition?
In the meantime, my lord.
156(3) ରେ ବୋଧେ ହେଇଥିବ ସେଟା କି protest petition ରେ cognizance ନେଇଥିବେ ସେମିତି କିଛି ଥିବ ଦେଖିଲେ
Nothing. No. Where is the protest petition? Nothing. What is your grievance?
My lord, we have challenged the FIR.
Madam, the FIR, according to you, the FIR investigation has taken place and they filed the closure report. That's what you say.
Yes, my
Isn't
lord.
it?
The case can be disposed of.
Well, she has mentioned her petition, page number 3, para 2, my lord. That to the present petitioner, and beside that, the opposite party number 2 has also given a tune of amount rupees 18,50,000, my lord. Reading that. So the matter may be closed there, my lord. If this petitioner has returned the money, there were 420, my lord, 420 is there, my lord.
My lord, I will file the final form. Please keep it to another date.
No, what she says that she challenged the FIR.
Yes, my lord.
Meanwhile, the police had investigated, filed a closure report. Therefore, he wants disposal. Is it correct?
Yes, my lord.
Yes, that's what
Yes,
she
that's
says.
it. Money has also been
articulate. Is this correct that you have filed this petition seeking quashing of the FIR?
Yes, my lord.
Meanwhile, police investigated and filed a closure report. So
Yes, my
therefore,
lord.
you don't want to press this petition.
Yes,
Is
my
it
lord.
correct?
Yes, my lord.
That's what. I know. The petitioner has challenged the and the petitioner has filed the present petition seeking quashing of the FIR. The numbers also. What is your name?
My lord, is fine.
A is fine. Learned counsel for the petitioner submits that meanwhile investigation is completed and the police has filed a closure report. In that view of the matter, the present petition is infructuous. Infructuous. Accordingly, the petition is disposed. Okay. Now we understood, all of us. Thank you.
46.
After vacation, my lord.
After vacation.
47.
May I please, your lordship? The petition, my lord, sought for the recall of the witness, my lord.
Who are you?
I am the accused, my lord. I am the
Whose application was that?
The accused application, my lord, for recalling the witness, my lord, was rejected.
1 and 2.
My lord.
What is the offense?
My lord, offense is 363, 363, 76, 2N with 4 POCSO, my lord. And the
criminal proceeding here, which is of the year 1982, Miller.
Only.
Miller. The case, in that case, Miller, offenses were under.
What is the state?
Case is under offenses under section 147, 148, 302, 149 of IPC.
302.
Yes, ma'am. And the section 5 of the Indian Explosive Act.
302.
And Miller, in that case, Miller, more than 200 accused persons were there. There was a quarrel between 2 villages.
A mob attack.
Yes, my lord.
Writing mob and all, yes.
Miller. And the case was adjudicated, trial, and judgment was passed, Miller, acquitting all the accused persons.
1984.
84, Miller.
Right. Where were you?
Under section 232.
Where were you?
I was Miller in the village, including 200 people. I was charge sheeted as accused number 60, and 59 were arrested, and they had faced the trial. I am a daily laborer. More than 200 people were involved. Police charge sheeted 60 people. And I am unfortunate, I was number 60 in the, your lordship may turn to.
No, you, charge sheet was filed against 60 accused persons.
Yes, my lord.
And all of them were put to trial.
All.
Except you.
My lord.
You were absconding.
My lord, obviously,
How many accused persons were subjected to trial?
Subjected to trial, 59 accused persons.
You are the last one.
I was the last one.
Show me from the judgment what is the.
Miller.
Where is that judgment?
Your lordship may turn to page 49.
40?
49, it's page 44, Annex 3, Miller. That is the order sheet of Sessions Court, Miller.
You show me the relevant part.
Miller, your lordship may turn to 59, accused serial number 59, page 47. That is Babuli alias Umaganda Patnaik. And the petitioner, Miller, here. Your lordship may see the order dated 30th 11/84, Miller. The accused Lingaraj and Nirmal are produced on the same day. The other accused persons are present. Perused the evidence. It is found that there is absolutely no incriminating evidence against any of the accused persons. Hence, examination of the accused persons under section 313 CRPC is dispensed with. The accused persons are acquitted under section 232 CRPC.
All the accused persons.
All the accused persons, Miller. Hence, all the accused persons are acquitted under section 232 CRPC.
Yes, Mr. Lord, what is that? Nothing.
Yes, my lord. Judgment is there.
There is nothing.
Let him.
332.
Yes, my lord, already.
1984.
Learned friend has
After 42 years, my lord.
Right out. The petitioner, petitioner has challenged. Petitioner is an accused in a FIR number so. Okay. There are land counts for the petitioner submits that there are as many as 200 accused persons. 200 accused persons involved in the present case. However, the police had filed charges against 60 accused persons. 60 accused persons. And the petitioner is one amongst them. 59 accused persons were subjected to trial. By the order dated 30th 11/2024, 1984, the letter trial court has passed the following order. It an page 47. All the accused persons, all the 59 accused persons have already been acquitted way back in 1984. The petitioner is a rustic villager however, he was shown as an abscond. Of late, he came to know regarding the matter and approached this court. Seeking quashing up the entire proceeding against him. Taking into consideration the fact that all the 59 accused persons have already been acquitted by the order dated 30/11/2024 passed by 84 passed by Sessions Court. What is that? Passed by
the Sessions Judge Puri, Miller.
Judge Puri
In ST case number 836 of.
And the case pertaining to an incident of 1982. 1982. I'm inclined to allow the petition. Accordingly, the FIR and the consequential proceeding arising therefrom was
GR case number 2187A of 1982,
written.
arising out of Konas PS case number 87 of 1982, pending before the JMFC Konas Miller.
Was in view of the judgment, in view of the judgment of the Honorable Supreme Court or in Ghansing and BCTC.
Oh, bless me.
Yes.
51.
May I please, O Lordship? My Lord, the petitioner challenges the order dated
Yes.
27/9/2023 passed in 16356 of 2009 on the file of the JMFC Berhampur. The petitioner is facing trial under section 138 NA Act. The case was posted on that day for cross-examination of the petitioner by the complainant. On that day, the accused petitioner was present, but all of a sudden he felt illness. Hence, he called his manager and go back to his house. And a time petition was prayed on his behalf, and time was rejected by the learned trial court. And closed evidence posted for argument.
What is the check amount?
Petitioner lost his right to adduce evidence.
What is the check amount? Check amount.
9 lakhs, no lecture. Petitioner already filed a affidavit in chief on 17/4/2023.
Okay, please, 138 matter, let us issue notice. Yes, next. 52.
After this, after.
Application was rejected, my lord. The land could be low.
Application under 300
Yeah, my lord. And file petitions annex 1 for repealing the PW8 to the IO, my lord. So it's not at all procedure.
Where is the testimony of IO?
My lord?
Where is the testimony of IO?
These are not active or procedure. Only people are. Okay, that's a good to go.
Why is it not procedure?
But the advocate was not actually good.
So which reason you are after? Then figure was not been processed. What is the offense?
But only 307 and 11 of the order of business, my lord. Juvenile, my lord.
See, is not cross.
My lord, you already mentioned that in the instant case that the defense counsel was present on the day of the examination of.
And you know the quality of drafting trial court.
Yes,
In one opportunity.
yes,
Need to get one opportunity reserved.
yes.
Calculate copy of testimony of PW 8. IU 5. IU of the case, Very few are required, nothing is not given anything.
Paragraph 200 mentions the case number and case. Offenses.
What is this?
Mudakar case number. Mudakar. Paragraph 2.
Nirakar case number 45 of 1. Section 452 of the 323 of the 324 of the 326 of the 294 503 of the accordingly, the report is that
JJB for that.
accordingly,
JJB
for the directed to report the criminal opportunity on the dates to be fixed by the board below and recall the changes. Recall the changes. Which this
My lord.
allowed.
My lord, may I make a
पासवर्ड केतना अछि की पासवर्ड
119.
What is that?
Husband is there, wife is on BC. Wife is on BC. Husband.
My lord.
What is this?
Can you see ABLP number 5795 of 2023? First or second order was passed.
Yes.
In favor of the prisoner, neither complied nor might disclose this.
That is the reason he has filed for it.
And second,
Find out some ground and
application was filed, that was also dismissed. This is the third application and he is paying that due to delay in investigation. We are absconding and
My lord, I am relying upon two judgment, my lord, that right to speedy trial is a part of right to life under guarantee.
Don't tell all these things. 2021 FIR.
My lord.
And you
Not
know.
direct for instruction that.
Have you cooperated with investigation?
I have never been noticed, my lord.
You don't cooperate with the investigation. You keep on trying, filing 438 after 438, getting rejected. And on the ground of delay in investigation, you come here.
My lord.
What is this?
Lordship, direct, I will surrender and go on bail, my lord.
You do that already. Already you have that order with you. Already you go that, do that.
Lordship, may surrender and release on bail, madam.
Simply withdraw and avail the benefit given by the first 438. First hour, second hour. That's the better idea.
My lord.
You can't get better relief than that. Where is that order? Show me.
Yes.
Show me that order.
Order copy, I don't have that copy right now, my lord.
ABLK 52795.
Dated?
Dated.
That I don't have. Right now, I don't have the copy, my lord.
You tell so that I can record that.
Lordship, keep it to tomorrow. I will.
No. What tomorrow? This matter, I'll dismiss it. You don't. You file frivolous petitions, and you burden the court and without preparation.
Lordship, permitted to withdraw, my lord. I will.
No, permitted to withdraw to avail the benefit granted to you by that order. That's what I wanted to write. Unnecessary, this will come as a.
Lordship, that is AVL appeal number 5721 disposed upon 28/7/2022.
You say that. Land Council for the petitioner seeks to withdraw this petition to avail the benefit of the order passed by the coordinate bench in ABPL number
5721
5721
of 2021.
upon dated
Disposed upon 28/7/2022.
will you appear? Shall I record?
Well,
I'll record that on 30th June.
Well.
You appear on or before 30th June. Right on. Right on. Then council for the contact it is I will ask Mr. Land Council of the petitioner on instruction submits that his client will be appearing before the surrendering before the court below on or before 30th June 2024 and avail remedy under law as has been directed by the coordinate bench by this order dated. This he is giving some other order. You are giving some other.
well, there are two bail application.
Dita application, but dismiss you, but first or second.
First or second hour kuda ita na
5795.
5795.
5795 of 2023.
First or second hour 39. Good first hour.
5795.
Same day on its own bill.
5795.
June and avail the remedy as has been directed by the coordinate bench by the order dated 6/7/2023 in ABPL number 5795 of 2023. Yes.
55.
Huh?
311.
None appears in interest of the seated then.
56.
My lord, matters compromised between the parties, my lord. Put upon 17th for personal appearance.
Offense?
Offense 506 to 94 23 all the offenses are tribal.
24. 21st group.
21st.
20th.
My lord, pardon to mention item 54 till 30th of June I protected, my lord.
That indirectly you are protected.
My lord,
Indirectly you are protected.
Lordship may observe that, my lord. Lordship may observe that till the 30th June.
No course action till 30th.
57.
May I please the lords? Here, my lord, I am challenging the passing of entire proceeding. On the ground that no prime facie case is made out against this present petition. Your lordship kindly see the FIR, page 11. I am reading out, my lord. Mu K. Sriram, Swanso Gramo, 11/12/21 ଗାରାବନ୍ଧ ଥାନାରେ ହାଜର ହୋଇ ଆପଣଙ୍କୁ ଲିଖିତ ରିପୋର୍ଟ ଏହିକି ଯେ ଆଜିର ସମୟ ସକାଳ ପ୍ରାୟ 10 ଘଣ୍ଟା ସମୟ ବେଳେ ଆମ ଗ୍ରାମରୁ ମ୍ୟାକ୍ସ ପିକଅପ୍ ଯାହାର ନମ୍ବର 100 ଗାଡିରେ ମହେନ୍ଦ୍ରଗିରି ଦର୍ଶନ କରିବାକୁ ଗାଡିରେ ମୋର ମା କେ ମଣିମାଲା ଓ ଅନ୍ୟମାନେ ମିଶି ଗଲେ। ସେଠାରୁ ଦର୍ଶନ କରି ଫେରି ଆସୁଥିବା ବେଳେ ଅପରାହ୍ନ 4 ଘଣ୍ଟା ସମୟ ବେଳେ ମାଡବା ଘାଟି ବୁଲାଣୀରେ ଡ୍ରାଇଭର ଲକ୍ଷ୍ମଣ ପ୍ରଧାନ ପିତା ହରିପ୍ରଧାନ ବେପାରୁଆ ଦ୍ରୁତ ଗତିରେ ଗାଡି ଚଳାଇବାରେ ଭାରସାମ୍ୟ ହରାଇ ଗାଡିଟି ଖାଲକୁ ଓଲଟି ପଡିଗଲା, ଯାହା ଫଳରେ ମୋର ମା କେ ମଣିମାଲା ଘଟଣାସ୍ଥଳରେ ମରିଗଲେ ଓ ଗାଡିରେ ଅନ୍ୟମାନେ ବସିଥିବା ଗୁରୁତର ଆଘାତ। Petitioner is not my lord Lakshmana Pradhan, who is the driver of the vehicle. The petitioner also not the owner of the vehicle. The police submitted the charge sheet. Your lordship kindly see the charge sheet.
You are K. Venugopal.
Yes, my lord. I am K. Venugopal. My allegation against me, the police submitted my lord charge sheet. Your lordship kindly see page 37. In the charge sheet, my lord, police submitted against me that I have arranged a feast there. Only on the basis of that, my lord, the alleged offense, my lord, under section 337, 338, 3.
No, where you have arranged feast?
My lord,
Where have you arranged the feast?
on the peak of the Mahendragiri, my lord. on top.
That's the reason accident taken place.
They are saying that the persons go there and they darshan the Lord, my lord, and thereafter while returning the vehicle capsized and one person died.
Let us see what are the allegations against you in the charge sheet.
Allegation, my lord, against me, my lord, there is only, my lord, that para you lordship kindly see. There is no allegation except this, my lord. Only I have arranged a feast there. Except that, my lord, no allegation is there, my lord. I am neither, my lord, I am in the vehicle, nor, my lord, there is any allegation of hurt or grievous hurt, nor I am also the owner of the vehicle or driver of the vehicle. And the offense, your lordship kindly see, the offense are also not made out against the present petitioner.
Yes.
Your lordship can turn to page 44.
40?
Oh, 44. 44.
I understood it. That you have.
My lord. Why, my lord, I have enclosed here with page 44, my lord, it is all the offences are summoned, my lord, procedural, my lord. That's why, my lord, they have filed a petition for discharge. That was rejected. I have not challenged them. That annexure because of the what is the stage? The stage, my lord, I have enclosed.
I have to see whether any prima facie case is made out or not.
Yes,
that's all.
Your lordship
You
kindly
tell me
if there is prima facie case made out, your lordship reject me.
Fair is not an answer to the
FIR nahi, charge sheet.
Apart from that, page 44 is very clear.
Yes.
That the magistrate has found prima facie case and the application 239 is rejected and charge has been paid and the case has been posted for trial 28/2/2024. That date is posted for evidence.
What are the allegations?
Yes, my lord. Your lordship kindly see the allegation, man. No, enter charge sheet I filed.
Charge sheet record some statement.
Where are the statements? 161 statement.
161 statement.
How will I come to know?
My lord,
cognizance is taken on the basis of charge sheet. You file the only charge sheet. Where are the evidence?
Only the charge sheet.
I know that.
My lord, direct my lord friend to.
Right, you are petitioner. Why should I direct?
Then I will produce, my lord.
Produce.
I will produce.
Let counsel for the petitioner seeks time to file.
All the offense, if I will read, my lord, there is no case, my lord, against this.
If you want me to arrive at a conclusion that no case is made out, I need to know what are the documents.
Yes, my lord, I will produce. I will produce all the documents.
Yes, urgent. Here, next.
58.
This case, my lord, is having a checkered career in the sense earlier anticipatory bail was filed. Also, my lord, the investigation was challenged. My lord, now, my lord, charge sheet has been submitted and cognizance has been taken for the offence under section 306/34. My lord, may kindly see the FIR with the basis of the case. My lord, at page 12. ମୁଁ ଏକ ଛୋଟ ଚାଷୀ ଅଟେ ମୋର ଘରୋଇ ଖର୍ଚ୍ଚ ତଥା ଋଣ ପରିଶୋଧ ପାଇଁ ଟଙ୍କା ଦରକାର ହେବାରୁ ମୁଁ ମୋର ଭାଗପ୍ରାପ୍ତ ଖୁଜିଆନ ଭାଗ ବାହାଲ ପାଣି 1 ଏକର 50 ଡେସିମିଲ ଜମିକୁ ସୋଆଂଶ ହରିହର ବେହେରା ପୃଷ୍ଠା କୃତଚନ୍ଦ୍ର ବେହେରାଙ୍କ ଠାରେ ଜମି ବନ୍ଧକ ରଖି 2 ଲକ୍ଷ ଟଙ୍କା ଆଣିଥିଲି। ଆମ୍ଭ ଜମି ଇସମାଇଲ ଜମି ଅଟେ। ଉକ୍ତ ବନ୍ଧକ ଜମିକୁ ସେମାନେ ବାକି ଟଙ୍କା ଦେଇ ନିଜ ନାମରେ ରେଜିଷ୍ଟ୍ରି କରିଦେବା ପାଇଁ ମୋର ମୃତ ପୁଅ ହରିହର ବେହେରା ଓ ତାଙ୍କ ପୁଅ ଲକ୍ଷ୍ମଣ ବେହେରା ଓ ନାରାୟଣ ବେହେରା ମିଶି ଅନେକ ଦିନରୁ ଚାପ ପକାଉଥିଲେ। ସେମାନେ ମୋର ପୁଅକୁ କାମଧାମ କର ଓ ଆମ୍ଭ ନେଇଥିବା ସମସ୍ତ ଟଙ୍କା ସୁଝି ନଦେଲେ ତୁମର ଜମିକୁ ଆମକୁ ରେଜିଷ୍ଟ୍ରି କରିଦିଅ ବୋଲି ଅସଭ୍ୟ ଭାଷାରେ ଗାଳିଗୁଲଜ କରୁଥିଲେ। ଘଟଣା ପୂର୍ବରୁ ପ୍ରାୟ 6 ମାସ ହେବ ସେ ଏଇ କଥା ତା ମାଆଙ୍କୁ କହିଥିଲା। ପରେ ମୁଁ ହରିହର ବେହେରାକୁ ଭେଟି ମୋ ପୁଅକୁ କିଛି କଥା ନ କହିବା ପାଇଁ ମନା କରିଥିଲି, କିନ୍ତୁ ସେମାନେ ମାନି ନଥିଲେ। ସେମାନେ ମୋର ଏକମାତ୍ର ପୁଅକୁ ମାନସିକ ଚାପ ପକାଉଥିଲେ। ଶେଷରେ ଗତ 13/2/2023 ଦିନ 7 ଘଣ୍ଟା ସମୟରେ ମୋର ପୁଅ ସେମାନଙ୍କର କଟୁ କଥାକୁ ସହି ନ ପାରି ବିଷ ପିଇଦେଲା। So this is the case. whether accepting the entire case of the prosecution, offense under section 306 is made out. But I am showing three decisions before my lord.
What has come in the investigation?
Investigation is like
What are
that,
the other
same matter.
Same.
ମାଗି ପଇସା ମାଗୁଥିଲେ ପଇସା ଯାହା ଦେଇଥିଲା ସେ ପଇସା ମାଗୁଥିଲେ.
And he came under the pressure
Yes,
and took the extreme step.
directly on the point my lord, a recent judgment of Gujarat High Court, but that has been they have taken note of Apex Court, exactly my lord, same case. That it is alleged in the affair that the deceased had borrowed money from the present applicant, and the applicant was often demanding repayment along with interest, and the husband of the complainant could not make arrangement of the money and thus remained under tension. It is alleged that applicant used to often threaten him on phone for the money and thus had instigated the complainant husband to commit suicide. It has been quashed. Relying upon 2002 Supreme Court, 2019 Supreme Court, 2011 Supreme Court and other. And my lord must have gone through number of cases.
The fact of this case is totally different than the fact of this present case. But the affair has been lost, investigation commenced. After completion of an investigation, police submitted charge sheet, and the statement recorded by the police clearly reveals that it is a case of 306. And apart from that, the entire case is based on the suicidal note. You'll also make kind
Yes, I am also concerned about
51.
So that.
51.
Yes, 51. Yes, 51. What is? Oh, sorry. Then I am reading. I am reading the case 51. I am reading. I am having the entire record. Mu Kunjo Bihari Behera, Pita Sultan Behera, so and so. Mo Bapa, Badangara, Farahar Behera Mataru, Amor Zombie Bondha Rocky, 2 lakh aଣିଛନ୍ତି ଏହି ବାବଦକୁ ନେଇ ହରିହର ବେହେରା ଓ ତାଙ୍କ ଦୁଇ ପୁଅ ମୋତେ ବାରମ୍ବାର ଜମି ରେଜିଷ୍ଟ୍ରି କରିଦେବାକୁ ଚାପ ପକାଇ ଡରାଇ ଧମକାଇ ଥିବାରୁ ମୋତେ ବହୁତ ଖରାପ ଲାଗୁଛି। ସେମାନେ ତୋ ଜୀବନ ବେକାର, ତୁ ଏତେ ବୟସ ହେଲୁଣି କିଛି କାମ କରୁନୁ, ତୋ ବଞ୍ଚିବା ମୂଲ୍ୟହୀନ ବୋଲି କହୁଛନ୍ତି। ମୁଁ ମୋର ମାନସିକ ଭାରସାମ୍ୟ ହରାଇଛି, ଯଦି ମୁଁ କେବେ ବିଷ ଖାଏ ଏହି 3 ଜଣ ଦାୟୀ ହେବେ। So
when this declaration? Suicide note.
This is the dying declaration made on 13/2/2008. The suicidal note on 13/2/2023. It has been seized on.
When he died?
22nd, madam.
22nd.
20th.
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 And this was made on?
This was made on 13/2/2023.
That is not, my lord, the proximate cause. Even my lord, husbands have
7 days before he is returning.
Yes. He has given this suicidal note, and this has been sealed, and the statement corroborates the statement of the suicidal note.
What is the law? If the
law is, my lord, even my lord,
note is written 7 days back.
And that too, even my lord, cases are there of the apex court. Do and commit suicide. Go and commit suicide.
Sudden and immediate provocation.
Yes, go and commit suicide. That has also not been. That has also not been come under the ambit of section 306.
Suicidal note. 7 days, written 7 days back.
So anybody can commit suicide.
20th, suicide note written in 13.
So that is the investigation. That is the suicidal note which has been sealed by the investigating officer. The entire case is based on the you'll also make kindly see.
What happened on 20th? Before, just immediately before 20th.
Nothing is there. But continuous. He has taken money and he was asking for money.
Just read.
My lord may see. Before going to 306, my lord may see section 107 of the Indian Penal Code, my lord. Yeah, listen.
Then that is again problematic.
He died on
when he took the
poison.
That's important.
Yes.
Immediately preceding that note, if he has taken
13, my lord. Affair is 13. Affair is 13.
He died on
20th.
What's the time difference between consuming poison and the suicide?
Dying declaration. Suicidal note.
Suicide note. what is the time gap between the
My lord.
note and the consumption of the poison?
I'll draw my lord's attention to a judgment of the apex court. I have also thought of in that line, my lord. My lord may see 2002, volume 5, SCC 371, my lord. See.
Do you have that? Let us get the facts first.
My lord, this is same day. This is same day, not after 7 days.
What is
Same
the
day.
time difference?
My lord, on same day, the time. Yes, sir. এটা হচ্ছে 13/2/2023 তার সে বিষ খাইছি সেই 13/2 রাত্রিরে বিষ খাইছি রাত্রিরে বিষ খাইছি
Then
Well, I'm coming to
get
that.
over this.
I'm coming to that, my lord. I was conscious that was by me a suicidal note. My lord may see this. 2002, volume 5, SCC 371.
Get over this.
My lord.
Yes.
Even if, my lord, paragraph 8, my lord,
Para 8?
no, my lord, that has been taken note of by Karnataka. I'm just giving, my lord. Before going to that, my lord, may see. Well,
Sanju.
let me see this first. Well, let me see paragraph 16.
Yes. Abatement.
Abatement is defined under section 107 of the Indian Penal Code, 1860. Abatement of a thing, a person is said abate the doing of a thing who first instigates any person to do that thing, or secondly, engages with one or more other person or persons in any conspiracy for the doing of that thing, if an act or illegal omission takes place in pursuance of that conspiracy, and in order to the doing of that thing, or intentionally aids by any act or illegal omission the doing of that thing. 17. As per the aforesaid definition, there should be instigation to do that thing. Ballot may kindly take note of. And then it amounts to abatement. A person is said to have instigated another to an act when he actively suggests or stimulates him to act by means of language, direct or indirect, whether it takes the form of express solicitation or of hints, insinuation, or encouragement.
I think these people will also.
My lord, may see this, my lord. Why, wait, please wait. Why I have drawn my lord's attention to paragraph 16 and 17? Because in 18, the court has taken note of even the dying declaration where it is said to go and die. That was the.
Even we accept the prosecution.
Even if we accept the prosecution story that the appellant did tell the deceased to go and die, that itself does not constitute the ingredients of instigation. There must be, my lord. I asked for my money. If he will be sentimental and he will commit suicide, then what is to me, my lord? I have got every right because his father says he has taken money. Then anyone can be, my lord, if who's a bit sentimental.
Whether it is incitement,
yes,
or urging to do some drastic or
yes, I insisted upon, my lord, even
stimulate or incite.
Yes, what stimulation, my lord? I asked for money. I asked for my money. I have not said you committed suicide.
Is it not that this has to be adduced in evidence and to?
Yes.
No, my lord, that has been passed. Here the apex court has passed. Even my lord, Gujarat High Court in similar case.
The
Wait.
Wait, let him complete. Let him
complete. Don't be
Yes.
It is alleged in the affair that the deceased had borrowed money from the present applicant.
Yes. This matter, your same matter.
2022 SCC.
Yes, 2022.
My lord, another judgment.
And what about this 2002?
2002 Supreme Court, my lord. That is the Supreme Court judgment.
You relying upon which paragraph?
My lord, I am relying upon. That is, my lord. Underline me, Corona. That has been taken note of by Karnataka High Court in paragraph 18.
18.
Paragraph 18, my lord, may say they have quoted it. My lord may see, wait. Let me see. My lord may see paragraph 12, Supreme Court judgment.
2002?
2002,
Yes, 5 ACC.
5 SCC, page 371. I'm reading the entire thing, my lord.
Paragraph.
Reverting to the facts of the case, both the courts below have erroneously accepted the prosecution's story that the suicide by the deceased is the direct result of quarrel that has taken place on 25/7/98, wherein it is alleged that the appellant had used abusive language and reportedly told the deceased to go and die. For this, court relied on a statement of Sassi Bhushan, brother of the deceased, made under 161 CRPC, when reportedly the deceased, after coming back from the house of the appellant, told him that the appellant had humiliated him and abused him with filthy language. What? The statement of Sassi Bhushan, recorded under 161 CRPC, is annexed as P3 to this appeal. And going through the statement, we find he has not stated the deceased had told him that the appellant had asked him to go and die. Even if we accept the prosecution's story that the appellant did tell the deceased to go and die, that itself does not constitute the ingredients of instigation. The word instigate denotes incitement or urging to do some drastic or inadvisable action, or to stimulate or incite. Presence of mens rea, therefore, is the necessary concomitant of the instigation. It is commonly recognized that the words uttered in a quarrel or in spur of the movement cannot be taken to be uttered with mens rea. It is in fit of anger and emotion. Secondly, the alleged abusive words said
Yes,
to
in
be...
what context he has said go and die?
Yes,
That's very
yes.
important.
But here only, my lord, I was asking for money. If you are not doing work, how you will pay my money? Or you just register the land in my name.
You give
What?
that.
What mistake I have committed, my lord, asking for my money?
I understand.
And that too, that has been taken note of. Why I was drawing my lord's attention to Gujarat judgment. But let me see this.
Gujarat High Court. Give me the
2020
copy. Give me the
SCC
copy.
online. I have given, I think. My lord, let me see.
I'm holding up
My lord,
the Karnataka.
2020 SCC online, Gujarat 1189. It is alleged in the affair that the deceased had borrowed money from the present applicant, and the applicant was often demanding repayment along with interest. And the husband of the complainant could not make arrangement of the money and thus remained under tension. It is also alleged the applicant used to often threaten him on phone for money and thus had instigated the complainant husband to commit suicide. Here, Honorable Court was pleased to, but here also suicidal note was there.
Where is that?
But let me see, paragraph 5. Harassment with there being any positive action proximate to the time of occurrence on the part of the accused 306 IPC is not sustainable. So and so, my lord. My lord, may kindly see paragraph 10.
These also had given a dying declaration.
My lord. My lord, it is very clear, my lord. Then anybody can, my lord, if my lord will say something to a person who should have done a particular thing and has not been done. And if you will take it to his heart and he will commit suicide, giving a note that on being directed by a court, I could not do it, I am committing suicide. So everybody will be held responsible for that. But let me kindly see paragraph 10 of that judgment. In the judgment of the Honorable Apex Court in 2011, volume 3, SSC 626, my lord. They have already, it has been, accordingly, my lord, the charge sheet has been passed here. Same case. And good number of judgments, my lord, till 2023, my lord.
You are, this is cognizance.
Bagra?
This is cognizance stage.
Yes, I am also in cognizance stage. I am quite conscious, my lord, there are good many judgments with regards to challenging appeal after conviction. But good, our High Court as my lord, has also decided many cases, my lord. I just brought some Supreme Court judgments. And good number of cases are there. While if you will be fixed up for hearing, I will argue the case.
No, I will reserve the judgment.
My lord.
That's true.
My lord,
you give the entire recording. 161 statement.
Everything and
You have a 161 statement.
everything.
and another judgment.
And I have also a flat.
Take it, huh?
or if my lord would direct me, I'll give it short note by day after tomorrow.
You please.
I was preparing it. I thought it may not be necessary for
No, please do give.
admission matter. Yes.
Yes. Next one. 59.
Yes.
Here I have challenged the order of cognizance. Under annex 4, my lord.
Yes.
The fact of the case that petitioner as well as opposite party number 2, both are employee under the MKCG Medical Hospital, Barampur, my lord. She has earlier sexual harassment made by the petitioner. And it was referred to the committee, sexual harassment committee. Committee gave me a clean sheet. That report I have also done. And some measures have been taken against me by the committee, madam. They have suggested.
After giving clean sheet.
After giving clean sheet. Madam, after that clean sheet was given, she has lost the FIR after 1.5 months of the occurrence. And alleging therein that no action has been taken by the authority, though I have made complaint.
Yes, where is that departmental committee?
Sexual harassment committee, page 37.
Yes, what does it say?
Page 37. No material evidence eyewitness could establish the aforesaid incident of inappropriate pinching beyond reasonable doubt. That report was submitted on 15/9/2023.
No, that page 37.
37. It was supplied to me.
What? Parasi, it says. You have filed there.
Again?
You have not filed the entire document.
Again? No, it was supplied, my lord. It was supplied under the ATI. I have made an application to supply me the report.
This is not a complete document.
Your lordship.
Para 37 starts from C. What is this?
Your lordship will kindly say page 35. On my application, they have supplied.
35 is something else.
No. Set up a report. Submission of a copy of a record submitted by the chairman.
Which item is this? This is 30, 50?
59.
59, 37.
Page 36. On my application, they have supplied the report that is under on page 37.
37, just see, 37 is not a complete document.
That they have supplied.
It's photocopy of
I have
2 paragraph.
2 paragraph.
Just see.
A, B, C.
A is not to be seen.
A no material evidence. That original document is
37 start with medical evidence. And what the start is medical evidence.
No, supply question now. No material evidence.
What C says that the respondent appears to be a dubious personality.
They have taken all measures. They have
does
taken
not have a clean image and has engaged in the past activity of which he was transferred from nursing school. However, this information has no direct relevance to the present complaint and cannot be proved either. As it appears that the respondent Kailash Sahu has taken advantage of his position and posting in this official also. Possibility
that action they have taken, but
possibility of the idea being put to the action of the capricious manner does not go unobserved and also should be placed in the official function. It's not a clean sheet, in fact.
No, so far as that particular incident is concerned, that is a clean sheet, man.
This is not a clean sheet.
Anyway, what is let us see what are the
that is valid on 15.
What are the allegation and what is the matter?
2023.
What are the allegation? Let us see.
She has lost the FIR.
Investigation is complete.
Complete. Cognizance order challenge.
Cognizance order, okay.
Both are employed.
Let us see what are the allegation.
My lord, the
inquiry report and suggestion was given on 15/9/2023.
Come to 161, just see 161.
No, no, ଆପଣ FIR and 22/9/2023.
161, 164, you read.
164
Huh?
164.
You have written, I don't know, you annex it to statement under 161 CRPC and 164 CRPC. You have written, how can I do? Fifteen to 24.
Page 15 is 161.
Read it. Read the complainant's statement.
That was recorded after 1.5 months.
Whatever. Cognizance is taken. Yes. Read it, read it.
ମୁଁ ଏତି ମସିହାରେ କାର୍ଯ୍ୟ କରି ଆସୁଛି ପ୍ରଥମେ ମୁଁ ଆକାଉଣ୍ଟ ସେକ୍ସନରେ ଥିଲି କିଛି ଦିନ ପରେ ସୁପରିଟେଣ୍ଡେଣ୍ଟ ଅଫିସରେ ତାପରେ ରେକର୍ଡ ସେକ୍ସନ 2018ରୁ ମେଡିସିନ ମେନ୍ ଷ୍ଟୋର ସେକ୍ସନରେ କାର୍ଯ୍ୟ କରିଅଛି ମୁଁ ଯେଉଁ ଅଫିସରେ ଡାଟା ଏଣ୍ଟ୍ରି କରୁଛି ସେଇ ଅଫିସ ରୁମରେ ଅନ୍ୟ 2 ଜଣ ଅଛନ୍ତି ସେମାନେ ହେଲେ ଆକ୍ଟର ସୋଆନସୋ ଯିଏକି ଏଡିସନାଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟ ଅଛନ୍ତି ଆଉ ଅନ୍ୟ ମଳୟ କୁମାର ସାହୁ ଯିଏକି ସିନିୟର ଫାର୍ମାସିଷ୍ଟ ଅଛନ୍ତି ଗତ 5/8/2023 ରେକର୍ଡେଡ ଅନ୍ 29/9 ମୁଁ ଅଫିସରେ ଥିବା ସମୟରେ ଏଟା ଜଣେ ସିନିୟର ଷ୍ଟୋର କିପର କୈଳାସ ଚନ୍ଦ୍ର ସାହୁ ପିଟିସନର ଆମ ଅଫିସ ରୁମକୁ ଆସିଲେ ପଣ୍ଡା ସାରଙ୍କ ସାମ୍ନାରେ ଚେୟାରରେ ବସିଲେ ସାରଙ୍କ ସାଙ୍ଗରେ କଥା ହେଲେ କଣ କଥା ହେଲେ ମୁଁ ଜାଣି ନାହିଁ 5 ମିନିଟ ପରେ ମୁଁ କୈଳାସ ସାହୁଙ୍କୁ ପଚାରିଲି ଯେ ଆଜ୍ଞା ସୋଆନସୋ ଆଣ୍ଟିଭାଇରସ ଅପଡେଟ ହେଲା କି ସେ ମତେ ହାତ ଠାରି କହିଲେ ରହ ମୁଁ ଆସୁଛି ସାଙ୍ଗେ ସାଙ୍ଗେ ଉଠିକି ମୋ ଚେୟାରକୁ ବସିଲେ ସେତେବେଳେ ପଣ୍ଡା ସାର ମୂଳଗମ ଥିଲେ ମତେ କହିଲେ ମୁଁ 3 ଦିନ ହେଲା ତୁମ ପାଖକୁ 3ଟା ବେଳେ ଆସି ଖୋଜୁଛି ତମେ ନଥାଉଛ ମୁଁ କହିଲି ସାର୍ ଖାଇକି ଆସିଲା ବେଳକୁ ଲେଟ୍ ହେଇଯାଉଛି ସେ ମତେ କହିଲେ ତମ ଚେୟାର ଟାୱେଲଟା ନେଇଯାଇ କଣ ସେ ମତେ କହିଲେ ତମ ଚେୟାର ପାଇଁ ଟାୱେଲଟା ଯାଇ ନେଇ ଆସିବ ମୁଁ ଯେତେବେଳେ ଡାକିବି ଏହା କହି ଏତିକି ମୋ ପାଖେ ଚେୟାରରେ ବସି ପଣ୍ଡା ସାର୍ ମଳୟବାବୁଙ୍କ ସହିତ କଥା ହେଲେ ପଣ୍ଡା ସାର୍ କାମ ଅଛି ବୋଲି କହି ବାହାରିଗଲେ କୈଳାସ ସାହୁ ମଳୟବାବୁ ସହିତ କଥା ହଉଥିଲେ କିଛି ସମୟ କୈଳାସ ସାହୁ ମତେ ଡାକି କହିଲେ କଣ କରୁଛ ମୁଁ କହିଲି ଅନଲାଇନ ପେଣ୍ଡିଂ କାମ କରୁଛି ମୁଁ କାନରେ ବ୍ୟସ୍ତ ରହିଲି ହଠାତ୍ ମୋ ସୋଆନସୋ
Their allegations.
No, ମୁଁ ଆଗେ କଣ କହୁଛି ମୁଁ କହୁଛି these allegations she has made before her employer.
We are at cognizance.
ମୁଁ ଆଗେ ଟିକେ କହୁଛି she has made these
I
allegations.
understand what you are saying.
And I have faced the proceeding.
The proceeding is not a clean sheet.
No, so far as when this particular incident is concerned, there
are other evidences also.
कहीं नहीं.
Anyway, cognizance is taken. I will not interfere. You approach at the right stage.
My lord, your lordship will kindly see. Both are the employees of the.
If you settle, I will record it. If you settle to that extent, I can interfere. Otherwise, there are allegations under 161. You have misbehaved with that lady in the office. This is the allegation.
That was inquired into.
Inquired into, it's not a clean sheet. You are a dubious character. That is what the department also writes. And your conduct is source. In what way you are treating the women employees in this office? Will you? I am giving you that liberty to.
नहीं your lordship में notice जाओ. Interim stay दफ्तर नहीं notice टा कर जाओ.
ये कौन हो notice?
जाओ opposite part number 2 पर.
Shall I record that you will settle with this?
सीटा इटा इनके आगे कोई नहीं. Hey, notice टा जाओ. Because one point I have taken on the particular issue matter there is clear.
Issue notice. We will not waste for that time. Yes. Issue notice. Yes. Next. But you don't have a case.
60.
Sexual harassment committee
See, the idea of sexual harassment, the whole idea will be defeated if court start interfering in this. And in the office room, there will be no rape in the working hour. This is the kind of harassment the women are facing. And if you can't prevent, then the entire idea of this sexual harassment and all is defeated. Do you expect that unless 354 is made out, unless extreme case of 376 is made out, then only the court should take cognizance? This is enough. You know, somebody is working, what kind of mental trauma that women must be having, or all these things will be proved in the trial. A cognizance stage, why should the court will interfere?
ଆପଣ false allegation ହଉନି?
No, no, false. Whether it is false or not, that will be tested in the right time. Yes, next 60.
My lord, I have challenging the cognizance order
Yes.
passed by the Lord JMFC Jotni, my lord. A allegation against my lord, the family member of the
ଆଉ ଗୋଟେ
informant, my
notice
lord.
ଗୋଟେ date ଟା fix କରିବେ?
Date to the visit. Somebody date fix. Date will be given. Yes.
My lord, in this case, my lord,
Hmm.
petitioner is false and fabrication study to and dispute between these properties, my lord. My lord, see the
Dispute between?
properties also vehicle, my lord. My lord, I have mentioned in FIR, my lord, see the FIR, my lord, page number 19, my lord. Page number 19, my lord, G,
Forget about FIR. Come to the charge sheet.
my lord.
What are the allegations against you?
Allegation, my lord, offense under section 498, 307.
Forget about sections. Don't tell the sections.
My lord.
Last page of the charge.
Allegations are there.
41, my lord.
Yes.
My lord, last, my lord, finding any other way field the case court on the IS Somyakant person 498, 307, 294, 324, 506. So also and directed to take investigation. This accordingly took investigation, examined the petitioner, other witnesses, and recorded the statement of 29/2023, my lord. Received this from CSI BBSR, went through which accused person named resolved, my lord, all the petitioners, my lord. And
All allegation is there.
All allegations.
All allegations.
All, not, you can't,
It's not only case of 493, it's a case of.
all allegations.
only between my lord, my lord, see the,
Husband of the opposite
my lord,
party
only
died.
property dispute. That means my
No,
lord,
no,
see this.
husband of the husband died, and thereafter you subjected this lady to so much of pressure or property. Learned counsel for the petitioner seeks to withdraw this petition to raise all this point at the appropriate stage before the court below. With this liberty, the petition is disposed of. Yes, next.
Okay.
61.
May I please, your lordship? My lords, in this application, the order rejecting the petition application under section 205 CRPC is under challenge, my lords.
Yes.
The offense is 409 IPC and the amount, my lords, is rupees 200, my lords. That is the my lords.
200.
200, my lords. That is the case, my lords. Allegation is that when the petitioner was working as a postmaster, my lords, at that time there are some 200 rupees of defalcation. That is the allegation, my lords. For that reason, my lords, the FIR was registered, cognizance was taken, my lords, and my lords, the petitioner was granted the relief under 41 ACRPC, my lords. He is on bail, my lords, and petitioner by the annexure 1, that is the petition filed by the petitioner for dispensing his personal appearance, my lords. Page
14, para 3.
14, huh?
Case 14, para 3. No more documents required.
Yes.
Paragraph.
In perusal of the case record, it is seen that the accused has been alleged to be separated 200 cognizance taken against him, and it is admitted of case that the accused that now he is residing in the quarter situated in the Reserve Police line under strong show, but the officer of the accused starts at 10 a.m. and he can appear before the court during the morning session, after which you can also give a bit of their. So everything is given.
Paragraph, paragraph 3 kindly see, my lords. That is the
I read it.
Paragraph 2, my lords. Paragraph 2, my lords. The counsel for the accused submitted the accused is a resident of village Buddha.
This also.
And is an employee under the postal department, my lords.
It's all right.
My lord, the accused is
317 benefit is given to you. Morning session you appear. 10 o'clock the court starts.
So it's a public servant, my lords. If he is compelled to come on his date, my lords, so not only he, also the public duty will also suffer, my lords. He is ready in paragraph, in that petition he has stated that whenever his personal,
is also saying the same thing.
whenever his personal attendance is required, he will appear, my lords. But on his date, his presence on
First appearance to Puri, so good to jive.
He appeared through his lawyer, my lords. He app-
205 भैया आपण गोटे थोर appear ହେଲା पर that is what the court says. तापर you can utilize 317. What is wrong in it?
My lords,
Here trial court has given full relief to you.
but that is, my lords, he is saying that morning hour, my lords, but morning hour that is not possible. When the matter will be taken up, it may come 10, 11 anytime. And is a public servant.
All these things, then you will say that I'm a late riser. I can't
No, that is not.
get up at 7 o'clock. That also
Yeah,
is
that is not that. I am not
a
saying.
trial court is considerate, so much considerate.
Morning hour, my lords, your lordship, he will appear whenever his personal attendance is required.
That's what he says, that go and appear. You tell me the date, I record it. On such and such you will appear.
Yes, my lord, any date.
You tell me.
Your lordship, my direct, my lords.
I will not direct. You have to tell me. ଆପଣ କୁହନ୍ତୁ
June 30.
June 30 forward.
ନାଇଁ ସେତେବେଳେ June 30 ରେ ମର୍ଣ୍ଣିଂ କୋର୍ଟ ନଥିବ ମର୍ଣ୍ଣିଂ କୋର୍ଟ ନଥିବ ନା that is the problem ମର୍ଣ୍ଣିଂ କୋର୍ଟ ସେତେବେଳେ ନଥିବ
16th
I'll tell on that day you will go and appear and yeah. What is the problem?
Appear and move on press application 205.
317 application court has already given relief. You are not appreciating it.
first appear କରିବେ ତାପରେ ଆପଣ 3 file କରିବେ
Let counsel for the the petitioner is agreed by the order dated
3/4/2024,
whereby his application under section 205 CRPC has been rejected. The letter court below, while rejecting the application, his application of 205 entries they are recorded as under para 3 of the impugn order at page 14. Letter counsel for the petitioner submits that he would be availing the benefit of this order by appearing before the court on which date? 20th.
30th. 20th.
30th of May.
30th of May.
May court must be on holidays, right?
But lower court continues.
Continue
Lower
on
court
30th of 30th May. On 20th. And thereafter move appropriate application under section 317 CRPC as directed by the court. You move application. Go take an appear easy. Dispose. Yes.
62.
May I please your lordship?
Yes.
Challenging the order of cognizance under Annex 4, running page 43, the petitioner has filed this petition. Initially, one FIR was registered against the present petitioner in an offense under section 454/392. Allegation against the petitioner is that the petitioner, along with others, reached in the showroom of the informant, where they have taken 17,000 some odd dress material and consumed alcohol in the showroom. Basing upon this allegation, initially 454 and 392 of the Indian Penal Code, FIR was registered against the petitioner and others. During the course of investigation, the petitioner was approached this honorable court in ABL appeal number 268.
395 edict.
Sushila Devi Agrawal and
petitioner was granted. The petitioner is an accused in FIR number so, and he approached this court by filing ABPL number 2689 of 2022. By order dated 6/4/2022, the petitioner has been granted the concession of anticipatory, the concession of pre-arrest bail, concession of pre-arrest bail. Thereafter, the charge sheet was filed against the petitioner, aiding an aggravated offense of under section 395. In that view of the matter, the petitioner is apprehensive that he may be taken into custody once he appears at the court. The apprehension is not well founded in view of the law laid down by the And Supreme Court in Susila Devi and
Susila Agrawal.
Susila
Satendra Kumar until.
Satendra Kumar.
Satendra Ante. The petitioner is granted the liberty to appear before court and move appropriate application.
63.
May I please, Lords?
Yes.
The notice under section 110 CRPC has been issued to me. They are the procedural law of 111. So 111 also say that already sum and substance of the allegation has to be supplied to me. But now in the notice it is only written the substance of allegation, the non-affair. Now I am not arguing say that matter also may grant the notice. A condition is put to me, a public servant, a government servant has to be stood surety for me. If that is prejudice to me, Lords.
You are antecedents. How many cases are there against you?
That I have no knowledge, Lords.
That's the whole difficulty.
You are a habitual offender.
How many cases are there? You need to know, no?
That is not.
That will
I have
that
no
will
knowledge.
decide.
That's
That
true,
will
Lord.
decide the kind of a bond you are asked to.
Yeah, Lordship of glance. I have no my family members have never been service in the government department, and my relation is also no
At a
government.
part, but you
Yeah,
see, when-
that part,
when-
Lordship.
Then I just don't understand one thing. At your stage, I need not tell you all these things. In a 310 case, the minimum requirement is you need to know how many cases are there against you. You are habitual offender, that is.
No, habitual offender, they have been stated, but I have no knowledge regarding whether
You must, when the client comes to you, first question is this, 110. If you have not asked, then you have not done your job.
But that's true, Lord.
And then you must tell the court that is 5 case, 6 case, 10 case or no case.
You go and file your so cause, that is the so cause.
Keep it to tomorrow.
And depending upon how many cases you have, the bail condition will be imposed. If you have many cases, they'll say whatever.
Even if you Lordship a glance, I have a criminal ancillary Lordship. And the condition
You tell me how many cases are.
That tomorrow Lordship keep it also.
Tomorrow I don't have time tomorrow.
So
cause you go and go, you should be ready with the material. See, what is the time? 3
correct, Lord, correct.
Number is 60. We have 130 men.
Correct, Lord.
Then
Correct, Lord.
why to waste time? Let the counsel for the petitioners to withdraw the petition to approach
Lord, shall I pray?
for variation of the condition of bail.
Condition of bond, Lordship, bond.
Condition of bond sought to be furnished by him. If the petitioner moves such application, the same shall be considered on its own merit. Then counsel or the petitioner submits that none of his family member or relatives are government servant.
Yes, ma'am.
Therefore, it's difficult for him to arrange a surety of government servant, surety of solvent surety.
Yes,
solvent surety belongs to a
government employee.
Therefore, he needs modification of the notice. Modification of the modification of the condition enumerated in the notice dated 30/2/2024. Okay. Yes, disposal. You go and move application.
It's 30/3/2024, Lord.
24. Yes.
Obligations.
Petition is a lady matter. Initially, FIR was registered under section 341. Charge sheet has been submitted. 41 notice was issued. Now summons has been issued. During the course of investigation, 41 notice was issued to the petitioner and she was complied the same.
Now 307 is added.
No, initially 307 was there. Other co-accused who have approached this court have granted anticipatory bail in ABL number. Just now I am giving ABL number.
What is this order? 8/2019. Cognizance order.
I have challenged.
Because he has not got the bail.
41 notice was issued and I was complied the same.
So what do you want?
Others have already got anticipatory bail. May I surrender before the
go surrender and do whatever you want.
Jo 307 was there, the Lord and Magistrate should not be released the petitioner on bail. For that, this is the difficulty.
Sir, you are arguing 482. Why are you forgetting that? Are you arguing a 430?
No, your lordship,
Don't move there.
initially,
How can I-
FIR was registered against the present petitioner along with others 341, 323, 325.
I understand this much.
My lord.
What else? Cognizance, how cognizance order is bad?
Next.
Because you did not get the bail, therefore cognizance.
No, no, I have never approached.
Then I approach. Since I have not approached, therefore cognizance order is bad.
No,
What
my
do you
lord,
want?
41 notice was issued to the petitioner.
Then you are lucky. They should have arrested you.
No, my lord, the injury is simple in nature, not vital part of the body, and the petitioner has never.
How the cognizance order is bad, you justify. You challenge the cognizance order. All these things are not relevant.
307.
For the petitioner seeks to withdraw this petition to raise all the point at the appropriate stage of appropriate stage before the court below. With this delivered to the petitioner. You are in terms of yes.
Inevitable TC bar 2023.
TC bar 138 was on or before, yes.
67.
May I please, Your Lordship? In this case, also, background is that a state level scrutiny committee had finalized the report of the committee. After finalization, I challenged before this honorable court, and Your Lordship had stayed the proceeding. Annexure 4, page 27, Your Lordship. Page 28 is the relevant page. 29, sorry. 29 is the relevant.
Yes.
Your Lordship, in this case, Your Lordship, is no course of action pursuant to order dated 26/4/14 passed by the state level scrutiny FCC number.
Where are you reading?
My lord.
Where are you reading?
My lord.
Which page you are reading?
Page 29, Your Lordship.
29,
Your Lordship.
yes.
Yes, in this case, Your Lordship, 21/7/2014.
Yes.
No course of action pursuant to the order dated 26/4/2014 passed by the state level scrutiny committee in FCC number 36/11 under the annexure 15 be taken against the petitioner
Yes.
until further in the case of the petitioner files application for revocation of suspension. After that, my lord, FIR was filed on the same report. Annexure 1 page, Your Lordship. Annexure 1, page 16. With the same report which has been stated by this honorable court, FIR was filed. Page 16, Your Lordship. A final order 26/4/14 by the state level scrutiny committee. Page 16, annexure 1. Same. Your Lordship, in that context, I approached this honorable court. Same.
These have been earlier disposed of by this honorable court. We come to case 24. Case 22. Permitted the petitioner to urge all these pleas raised in the present application at the appropriate stage in the trial court. The CRMC is disposed of. The interim order passed, earlier stand vacated.
How will you get out?
Next, I approached the lower court again on page annexure 3.
And it is rejected.
Rejected. Then Your Lordship, similar case, Your Lordship, annexure 6, Your Lordship.
Same clearly, same
Just a minute.
that petition.
Annexure 6.
And vacated state.
Annexure
Exactly the same plea has been taken. And this honorable court, by the coordinate bench has directed to raise all these points at the appropriate in the trial. Before that, again, same application.
Annexure 6, Your Lordship. Similar order has been passed. Annexure 6.
In another, who is
Annexure 6, page 34, Your Lordship.
similar order in whose case?
Your Lordship, similar case, Your Lordship, same caste certificate matter. Annexure 6, page 34. Your Lordship. Wait. Annexure 6, page 34, Lordship. Relevant page 39, Your Lordship. Paragraph 7. In the aforesaid facts, I am of the considered opinion that until unless such writ petition is dismissed or stay there is in vacate, the prosecution cannot be said to have foundation to prove its case, inasmuch as the very order that the petitioner obtained spurious caste certificate is in eclipse by the interim order in the writ petition. In such peculiar facts and circumstances, it is directed that stay further proceeding.
What is happening to that stay order is continuing?
Continues. It is pending matter. No, it has moved ahead. Because Your Lordship, two cases cannot go ahead. In the writ petition, Your Lordship has stayed the final report. Self-same final report is the FIR.
The subject matter to decide.
Stay, Your Lordship.
Plea taken by them on the basis of the certificate.
No, what he's trying to say, I'll tell you. He's trying to say that the what report, what committee report is that?
Scrutiny
committee.
committee final report.
There is a scrutiny committee report.
Yes.
Is there? That scrutiny committee report was challenged in the writ petition.
Yes, sir.
There is an interim order saying that no coercive action pursuant to this scrutiny committee report. That order is still there, continuing.
Right.
Once this was continuing, he filed the FIR was lost basing on that scrutiny committee report only,
yes,
which could not have been done. Therefore, he came and challenged before this court. This court said that you raise all the points there court below. And he went and moved an application.
Yes.
That application is rejected.
Reject.
No. Where that application?
Yes, I have given.
So,
Where that application?
Yes, you see, I have given the.
Where is that application?
Yes, madam. Yes, madam.
Yes.
Petition ଲେଖା ହେଇଛି.
Where is that application? Where is the rejection order?
Yes, your lordship just annexure 3, page 25. Your lordship annexure 3, page 25. The case record is put up today.
9/9/2022 ପରେ
My lord.
trial court ଯାଇଥିଲେ ଆପଣ?
Yes.
Show me.
Page annexure 3, page 25. Annexure 3, page 25.
9/9/2000.
Order. What? On 18/4/24. The case record is put up today for order on petition dated 6/4/24, filed by the accused petitioner. Copy served on the council. Accused petitioner submitted. The petitioner filed a petition in pursuance to the direction of the Honorable High Court in criminal case now such and such.
Okay.
Disposed on 9/20. Wherein the Honorable Court.
Issue notice.
Yes, sir.
My lord.
Issue notice.
Petition me. Tapori your lordship may kindly turn
Yes,
to
sir.
page 26.
Yes, sir.
Hard both the sides. Peruse the entire case record. Along with the certified copy of the order of the Honorable High Court of Orissa filed by the accused petitioner. The Honorable High Court of Orissa has filed order dated 9/9/2022.
In criminal miscase.
Okay.
Wait.
CRMC number.
Look at it.
December 2015.
I know that.
Vacated the interim order.
Yes, sir.
passed earlier permitted the petitioner.
That's right, but in the writ petition, that interim order is still continuing. Writ petition, the committee report.
ମୁଁ ସେଇ ପ୍ଲେସରେ ଅଛି ଯେ ସେଇ ଆପ୍ଲିକେସନ ମଧ୍ୟ ଏଇ ଆପ୍ଲିକେସନରେ ଥିଲା
No.
No.
ଏ ଆପ୍ଲିକେସନ ଥିଲା
No. Show that writ petition order.
ନା ନା ଏଇ ଆପ୍ଲିକେସନଟା ଆଣିଲେ ଆପଣଙ୍କର ପିଟିସନଟା ଆଣିଲେ ଏଇ ପିଟିସନଟା ଆଣନ୍ତୁ
No. Writ petition order. Where is that writ petition order?
Writ petition order. Yes.
Yes. This writ petition order.
Annexure 4 units.
Annexure?
Annexure 4 units.
4.
Page, your lordship, relevant page 29 units. Similar, several cases,
Yes.
your lordship, not one.
This order passed way back in 2014.
14, my lord.
This
14.
writ petition is still pending.
Still pending.
ମୁଁ କହୁଛି in 2014 the writ petition was order was filed and that was pending. In 2015 thereafter the 482 application was filed. You also got my point. This 2015.
I know that was filed, and
Yes.
the court said that you raise all these points before court below.
Would be.
And he raised it, and now it is rejected. And this point, the point that, but see, point he has not raised, but this is the relevant point.
ଏଠି ଟ୍ରାଏଲ ଟାକୁ ଷ୍ଟେ କରାହେଇନି
Trial stage.
ତ ସେଇ ଅର୍ଡରଟା ହେଇଛି ତ ଏଠି ମୁଁ ସେଇ ପାଇଁ କମ୍ପ୍ଲିଟ
How will you tell me in the face of the order dated 21/7/2024, where the writ court says that you can't take any coercive action pursuant to the report dated 26/4/2024, how can you file a FIR? Just see the FIR. See the FIR at the top. See the FIR. Your FIR is based on that report.
Page 16.
There is a complete stay
Page 16.
operating.
Page 16.
Come to page 16.
16 ଦେଖନ୍ତୁ.
Final order dated 26/4/2024. On that basis, you have filed record an FIR.
Yes, sir.
Where there is a stay operating.
Report is the
How can you
FIR.
do that?
Report is the FIR. Final
Just
report
see page 16 at the top.
is 16 ଦେଖନ୍ତୁ.
This report is stayed by the writ court.
Several cases they've done it, but stay has been granted because you cannot go ahead with both the proceeding. You cannot. Writ petition,
I got that.
Right on. Wide report dated 26/4/2014. The scrutiny, the state level scrutiny committee had submitted a report dated 26/4/2014 regarding the fake case catch certificate issued in various cases. The said scrutiny committee report was subject matter of a writ petition. Writ petition. Where is that writ petition? Writ petition. writ petition being WPC number 12860 of 2014. The coordinate bench of this court by order dated 21/7/2014 passed an interim order in the writ petition, inter alia stating that no coercive action pursuant to the scrutiny committee report, pursuant to the order dated 26/4/2014 passed by the state level scrutiny committee in FCC number 36 of 11 shall be taken against the petitioners. Surprisingly, relying upon the same scrutiny committee report dated 26/4/2014, the instant FIR has been raised. Therefore, the petitioner is questioning the initiation of the proceeding against him through the FIR in subject. Issue notice to opposite party number 2, returnable so and so. In the meantime, proceeding before, where is it? Cognizance is taken?
Yes, sir. Your Lordship,
Proceeding before so and so is taken. Yes, next.
68.
Okay.
May I plead, Your Lordship? In this case, Your Lordship, I am challenging the order of cancellation of bail passed by the learned court below, Your Lordship.
After vacation. Let him enjoy vacation.
No, he has already been demanded custody.
Further, let him enjoy.
Lordship.
Cancellation of bail, what is the urgency?
No. Against me, the cancellation of bail was filed by the prosecution, which has been entertained by the court below, trial court, as a revisional court of this honorable court, Your Lordship. The bail was granted by this honorable court.
You are the accused?
Yes, Your Lordship. With certain terms.
Your bail is consent?
Yes, Your Lordship. My bail is consent.
I thought you are the informant.
No, I am not for the informant.
Your bail is consent, then it's urgent. Yes, tell me,
Your Lordship.
where is the bail order?
Yes, Your Lordship. Lordship may peruse bail order I have annexed under annexure 2, the relevant part, 21, page 21, Your Lordship.
Yes.
There are certain conditions fixed by this honorable court.
Yes.
1, 2, 3, and 4, Your Lordship.
Yes.
And relevant part is page number 22, Your Lordship. Second paragraph I am reading, Your Lordship. It is clarified that the court in session of the case will be at liberty to cancel the bail of the petitioner without further reference to the court, if any of the above conditions are violated. So the court has clarified if any of the four conditions are violated, the court in session.
Don't explain.
Yes, Your Lordship.
I know.
Or a case of cancellation of bail is otherwise made out.
Don't worry.
No, Your Lordship.
Don't explain me. Keep on reading. I will understand.
Next sentence starts. In the wake of aforesaid and
which condition you have violated, you tell me now.
Yes, Lordship.
What
I have been involved in subsequent 2 cases, Your Lordship. Taken care of that 2 cases. The prosecution filed a application under section 439.
Which condition you shall not be involved in?
That was not within that condition, Your Lordship. The petitioner shall attend the trial court on each and every date of posting. The petitioner shall not leave the jurisdiction.
Yes, which condition, Mr. Maharaja? Which condition is violated by you?
Not appearing before the jurisdictional police station.
Yes.
The Lordship may kindly turn to page 41.
41.
Yes. Page 41. The Honorable High Court, wide BL number that word is started from. The Honorable High Court.
41, no?
41.
41. Yes. The cancellation order. This is the cancellation order.
Yes, sure. Cancellation order.
41.
41.
41. The word starts from Honorable Court by order by BLPL number so and so dated Exhibit 2023 by violating the condition of the bail in not attending the jurisdictional police station as well as having involved in the substantive grave and serious offences in Brajaraj Nagar case number so and so. The bail of the accused is hereby cancelled.
Yes, sir.
What is the case? This case, Brajaraj Nagar?
That is under section 307, Your Lordship. Here, Your Lordship.
What is your profession?
I am a contractor, Your Lordship.
How many cases you have?
I am having 5 cases, Your Lordship.
No, you enjoy that. What?
Yes, Lordship. here, your lordship may peruse.
What about the investigation? In this case, investigation is over.
Lordship may peruse the
One
date.
minute, investigation is over.
In this case, the trial has commenced, your lordship.
See, then see, Mr. Maharaj, then the only condition which is violated is he has not appeared before the police.
Police and he has committed.
But that was not a precondition for bail. There, when this court granted bail, that was not a condition. That was not a condition. The condition is he shall appear before the police.
Police.
Charge sheet is filed, everything is filed, and this condition is neither here nor there.
Huh, trial chalchi par?
Trial judge, whether he should appear before police or not, how does it make difference?
That is
modified the condition because the once condition imposed the same unless until it is modified, it cannot be overlooked because he has to comply.
and that was for 6 months, your lordship. That condition was for 6 months.
So within that
And
6 months you have violated.
You should have gone to that court and moved an application for variation of that condition.
Lordship may peruse the date chart.
Forget it.
Lordship may peruse. I have been enlarged on bail on 31/3, your lordship. And that condition was for 6 months. And when they filed a
But you
439.
tell me, even if I grant the bail, the condition imposed by the that court will remain. I can't alter that condition.
That was for 6 months, your lordship. That condition was for 6 months. And after 8 months, they filed a 439(2) application.
Where is that order?
Lordship may peruse the date chart, your lordship.
Get the
Date chart. I have completely,
to accept.
in detail, I have stated, your lordship.
Write down. The
On
petition-
31/3/2023.
It's all right. Right now, the petitioner was enlarged on bail by this court by the order dated 31/3/2023 in BAPL number 12039 of 2022.
No.
2022.
No, he case
তার উপরে
different.
petition লিখুন।
Oh.
Let it, Mr.
No, he
Papa-
cancelled.
ये case से already arrested.
Honest, I mean, that I,
आपण jail लो छोड़ना
he case jail रो. I have mentioned.
He has to file a regular bail, file करो ना, arrest ला once cancel मान दे।
Bail
No,
cancel,
no.
he was taken into custody. Bail cancel, he was taken into custody.
That's what I'm going to do. What I'm going to do.
He has to file bail application.
I will record everything. I'll relegate you to move application. I can't do that. He was granted bail and cancellation was not called for.
Yes,
Unnecessary it was cancelled.
but this is your lordship's consideration of which everybody has a word down their head because this is the situation.
Why? See, the
But
condition for
sometimes
6 months police and charge sheet is filed. Why he has to go and appear before police after charge sheet is filed?
See, what I said, condition ହେଇଯାଇଛି, ଏତିକି ଦିନ ପର୍ଯ୍ୟନ୍ତ
And he is
No, no.
ill-advised to, move up. You should have moved an application for variation of that condition.
Various ways.
No, I have already
Anyway,
been.
छोड़ो. Right on.
Cancellation order টা সেটা সেটা আমি করব।
Subject to condition that subject to various conditions, including the condition that the petitioner shall appear before the jurisdictional police once a week, preferably on Sunday, in between 10 a.m. to 12 noon for 6 months from the actual date of his release from the custody.
He released on 5/4.
It appears the petitioner when you fail to appear,
I released on 5/4/2023, your lordship.
petitioner was released from the custody on 5/4/2023. 23.
And this 439(2) was filed on 6/12/2023, your lordship.
It appears the prosecution has moved an application on the
6/12/2023, your lordship.
2023 under section 439(2) of CRPC on for cancellation of bail on 2 counts, namely for non-compliance of the conditions as stated above, and on the ground that the petitioner is also involved in PS case number. Where is that PS case number?
In 2 cases, your lordship.
In 2 cases.
Yes.
Subsequently,
Brajranagar
and
115 of 23 and 316 of 23, your lordship.
Mr. Mahapatra Land Council petition submits that insofar as they submit that this court had already enlarged him on bail. However, therefore, the bail should not have been cancelled on the ground that he is involved in subsequently involved in two other cases, and on the ground that bail condition has been
Violated as per the direction of, as per the order of this honorable.
violated. Next further. It is also stated that in the present case, the charge sheet has already been filed, and in which after framing of charges, a trial is progressing.
By the time the bail order.
Therefore, the condition imposed by this court to appear before the investigating officer is redundant. Moreover, the condition was only for 6 months.
Yes.
6 months. Since 6 months, and the petitioner has been diligently appearing before the police authority as per the condition laid down by this court. Therefore, the cancellation of the bail was uncalled for. Accordingly, he is sealing the change order before this court. Since the petitioner has already been taken into custody, the petitioner shall move appropriate application before the court below for regular bail. In the light of the order of this court passed in ABPL number BPL number 12039 of 2022. If such application is moved, the same shall be considered on the same day on its own. Yes, next.
69.
Yes.
Lordship, here is a very peculiar case, Lordship. I was going through the order of cognizance. Perhaps Lord Court has written new criminal jurisprudence, Lordship. Your Lordship kindly see the order. Lordship, the final form has been submitted by the investigating authority. Lordship, kindly state I come to page 39.
Yes.
Just I'm reading the long paragraph, Lordship. I'm reading Lordship, page 39. During course of investigation, the spot was visited. Complainant and witnesses were examined and their statements recorded under section 161 CRPC. During local inquiry, it is ascertained that the Dharadhir Sethi has got a computer institute styled as nano computer at Athagad since 13 to 14 years. On 15, 12 and 17, one Satya Prakash Ratha, Dibyaranjan Pani, Jagya Prasad Rajgur, Rajendra Prasad Mishra and Devi Prasad Mahanti came to his computer institute and requested him to impart a computer education to the students through Digital India program, and he will get commission of rupees 300 per students. They denied to do any written agreement in this regard. In the year 2018, Satya Prakash Ratha requested the complainant to open another institute at Dhenkanal, and accordingly the complainant provided some computers, chairs, tables and other accessories. The work started for about 5 to 6 months, and when the complainant asked Satya Prakash Ratha to give the commission, as promised, Satya Prakash Ratha and others became honored upon him and told him that they will not give a single part. Or there was quarrel between them, and Satya Prakash Ratha accused the complainant abused the complainant in absence language and on caste aspirations and threatened him against their consequence.
But what do you want to say?
Lordship, kindly come to the last paragraph. Last sentence, Lordship. And this case has been supervised by the SC party, OPS such and such, and complied the all instructions. Inquiry report has been done and submitted by such and order has been obtained from SP Cutter by such and such. Written the case for sufficient evidence such and such, insufficient evidence. Under the above circumstances, I submitted final form as FR in insufficient evidence by Athagada PS case such and such. Lordship, accordingly, it is in referred for kind action to court. Then Lordship, kindly the order of cognizance. Lordship, state Lordship, kindly come to
Forty-two,
Lordship.
page 42. Lordship, straight I come to page 43. Just I will draw Lordship kind of few lines. Lordship 43, last 2 lines. Certainly, the statements of other witnesses recorded by IO 161 lacks material particulars. Lordship, he admits there is no evidence of for the witnesses are concerned. Then Lordship kindly come to page 44. Just I will read Lordship 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 line Lordship. It is further surprising to note that when the FIR is elaborately descriptive, containing all material circumstances, and the statement of the informant and his wife are corroborative of all those circumstances, what prevented the IO to discard their evidence in the establish the truth? It is not always true that.
Yes, I am.
Yes. So, Lordship,
there are 2 witnesses.
Lordship,
Statement corroborates, and FIR is also detailed FIR. Therefore,
Lordship, kindly see the evidence. I have annexed the evidence, Lordship. Lordship, let me read it and I'll go. I have annexed all evidence.
Do I need to read everything at this stage?
Lordship, so Lordship, if you issue notice, then I have nothing to say, Lordship.
Why should I issue notice? Cognizance is rightly taken.
But Lordship, there are without any evidence. Lordship, kindly see. Here, Lordship, offense on 3 and assist act, Lordship. Only 2 ingredients should be available, Lordship.
The informant and his wife's statement corroborates,
Lordship,
and the FIR is a detailed FIR.
Lordship,
Therefore, the trial court says that
Lordship, the basic ingredients of the 3 assist act, Lordship, it must have been a public view. And Lordship, there must have
all these things perhaps you should argue at the stage of charge.
No, Lordship,
this is not made out.
Lordship, I am at the stage of cognizance because Lordship, kindly see, after thorough case of 2017, after thorough investigation, case has been charged in a much belated stage. And Lordship, kindly see the situation and the position of the petitioners. All are the government employees. And Lordship, kindly see, after 8 years,
I think see, cognizance order is a very detailed order.
But it is absurd, Lordship.
And
it is
all reasoning is given.
No, Lordship, that is why my humble submission. Lordship, kindly allow to read the entire, Lordship. I have marked the.
No, I will not read evidence and start analyzing.
I'm not saying the Lordship. It must be, Lordship.
The allegation attributable to cheating is a prima facie made out on the basis of FIR and the statement of informant and his wife.
Lordship, I am not on that, Lordship. I am basically, Lordship, if the ingredients of the offences are made out, then I don't have any case.
So you
on
are
the
saying
stage
that,
of Lordship,
you are saying that
cognizance,
out of all the offences, these particular offences are not made out.
Lordship, the basic main
charge is this.
No, Lordship, kindly see. What is the stage of cognizance? What is the meaning of cognizance? The court below will take, Lordship, read the
Come to page 45.
Right, 45, Lordship.
Middle.
45, Lordship. Lordship, kindly see. Well, he's written, Lordship.
His affirmation.
Yes.
The FIR that
Lordship,
persuaded
only
them.
the contents of the affair.
I'm saying to read it.
Lordship, which paragraph, Lordship?
In between.
In between, Lordship.
Fourth line. 45, page 45.
This allegation attributable, Lordship.
His affirmation.
His affirmation in the affair. When he pursued with them after completion of the project of his return, the accused person, please.
Yes,
the accused persons abused him in optional words. The language is written.
And
then, Lordship, supported by their 161 statements, is also appearing. Who are you, Lordship? You will dictate on me.
Let him read.
Very peculiar, Mr. Mara. What is this?
I am for the state. Don't forget. Don't forget.
Mr. Lordship is allowing this. Lordship is allowing this mischief.
You are saying,
What are you saying, sir? Lordship allowing this mischief. Lordship is allowing this type of mischief. Who is he, Lordship? Lordship, who is he? Lordship, who is he? You will tell me, Lordship, who is in the outer part? Who is the government of
this kind of situation happens, right?
Why happened, Lordship? Because I am continuously every activity, Lordship. From the hearing.
Okay, it's all right. I'll hear you tomorrow. Pull down and come. Okay, put it tomorrow.
Not expecting from the government council.
No, it's all right.
We are also not
Hold on.
We are not expecting.
These exchanges are not called for.
Who are you?
These exchanges are not called. You
cannot
are mature.
Lordship, he is locus, Lordship. Kindly see, Lordship. It has to be clarified first, Lordship.
No, he has
Lordship is interfering in my matters, Lordship. What is it? You should check his conduct. What is this?
This is
Okay,
good conduct.
tomorrow you pull down tomorrow. You will spoil your case tomorrow. Tomorrow I'll
Unaccept, Lordship.
all right.
Cool down.
We are coming for petitioner.
So
We are
cool
not
down.
coming for the
Okay, stop.
the government agents.
Next matter, next matter. Huh? You are next matter. Mr. Maharaj, please sit down.
Yes.
Please sit down. Why unnecessary?
Cadet should check it.
All right, हो गया. बस काम खत्म. Next.
Say 70. Very
And it's all right. Your matter is urgent for tomorrow. You cool down and come tomorrow. No problem. Yes, next.
70.
70.
70.
70. But it's all right. Sometimes this happens.
How was it? How?
अरे भाई
you people are behaving like school children.
जाओ तो समझे व्यवहार करके जाओ से कोर्ट में जाओ
Let him go.
से कोर्ट में जाओ बिहेव खराब होता है
You are behaving like school children. Why unnecessary? You people are so mature. Cool down. पानी अच्छी दे पानी दे पानी दे
what
are you not keeping water?
पानी दे
अब पानी पियो तू
पानी पियो बसो
पानी पियो तो cool down.
sometimes my lord
बसो
we are in a cool
Always you should be cool. Otherwise very dangerous in this
question arises my lord who are you what but this hot my heart who are you guy
Oh, पानी पियो. Okay, you drink water. I have also taken water.
sorry all like my lord I'm sorry
It's all right. No, it's all right. This happened. Yes. Next 70. See, better item 70. Better you ask for adjournment today.
ମୁଁ ଦେଖୁଛି ପାଗ ଭଲ ନାହିଁ.
Direct impact in your case.
tomorrow ଆସୁନ.
Tomorrow. And he is also cool down. Yes.
yes sir
He will not oppose now.
Case matter ଯିବା ଆଜ୍ଞା sir.
Yes, tell me.
The interim release of vehicle. Confiscation proceeding has been done.
Already done.
FAO has been preferred.
Then go and participate.
At this stage, my lord, this is a judgment of this honor. I relying upon this judgment of this honorable court. I have filed this because during pendency of the FAO also this honorable court in a criminal miscase allowed the
What is this?
subject to result of the FAO.
Which paragraph?
Last paragraph. Subject to the final order in the FAO.
No, for a reason, both the Puja by directing the authority to release the vehicle in favor of subject to the final affair.
Only basing upon this judgment, I filed this.
Yes, Mr. Agada.
Last paragraph.
He is directly covered by you.
Yes. Last paragraph. You know this one.
Subject to. You tell me, where is your application? FAO. Where is your application rejected?
The FAO preferred by state.
No, where is the
that
order?
Order judgment annexure 1 order, annexure 1.
Annexure?
1. Page 11. Judgment. That is the judgment passed by the law enforcement judge.
What is this order you have filed? This order dated 15/3/2024?
397 petition was rejected. 397 petition was rejected.
Annexure 1 is something else. You have filed a criminal MP number 2483.
Criminal revision. What happened in this case, my lord? A vehicle was seized. I filed an application before the law and SDGM. That was
I'm asking you just answer to me. Page 9. What is this order?
yes yes my lord here
Order.
I want to draw your attention.
What is this order?
I forgot this. This order was challenged before this honorable court, and this honorable court has categorically stated that since the competition proceeding is pending, you go and appeal for this court with the compensation authority and raise your funds. My Lordship, I can turn to London Council for the State referring to the affidavit of the range officer. Lordship got it?
Yes.
Page 10. Jagatsinghpur range, Jagatsinghpur.
He went and
In
participated.
the meanwhile, the seized vehicle in terms of the order passed by the authorized officer cum assistant commissioner of forest, Cutter. The vehicle in question has been confiscated.
Yes.
Not confiscation, if proceeding is going on. Is that?
No, who said?
No,
Who said? Mr. Maharaj, who said proceeding is going on?
You now you have seen this. Direct address me.
I'm
Don't
sorry,
address
madam.
him.
Conspiracy proceeding
What
sorry
he said,
FAO का file है
confiscation proceeding is
Confiscated like extra sector.
confiscated. He sarla. FOA is pending.
Yes.
What he says that subject to outcome, you allow my petition.
Yes.
That's what he says. Because this court, this judgment also says that.
Yes, say ये
Subject to
order.
outcome. That's what you say. You know.
देखो सेशन जज report ना pending ଅଛି ना subject to result of the FAO
Right.
vehicle
Petitioner
ସରିଲା ପରେ FAO ହେଇଛି
by filing CRLMP number 2483 of 2023 by order dated 15/3/2024. The petitioner was directed to participate in this confiscation proceeding, which was confiscation proceeding, which was going on before range officer, our Jagatsinghpur range. Jagatsinghpur range. Full stop. Pursuant thereto,
ଲେଖିଛି ଅବଡିରେ ଲେଖିଛି
the present petitioner had challenged petitioner had filed the petition seeking
ସପରେ କିଛି କରୁନି ସବୁ
passing
କଲା
of the order dated 30/10/2023 passed by
challenging that order ଆଉ
No, no, good. The vehicle confiscated, my lord. Against that, they my lord, file a FO before the sessions court, my lord. There they have to, my lord, file a IA for release of the vehicle, the pendency of the FO, my lord. And when that court rejected, man, they have to file a writ petition.
Have you read this
My
judgment?
lord,
This judgment says that subject to outcome, allow. Let him go and participate there. How do you the petitioner
referring all the judgment, this one looks good.
Where is the first order? Revision order is dated.
Revision order ଟା ଅଛି
କଣ file କରୁଛନ୍ତି?
First order that my lord page number
revision order dated ହେଉଛି 13/10/2023 page 11.
Where is the first order?
first order ସେ 21 पे ଅଛି second last को ଅଛି ଆଜ୍ଞା ଦେଇ ଯାଏ
କୋଉଟା ପରେ କୋଉଟା file କରୁଛନ୍ତି?
sorry I'm sorry not my
Where is that order? Page
page ହେଉଛି
21
21
starts from 21 what is it
21 ଟା page କହିଲି ନା ସେଇ କଥା ଏଇ ଗୋଟେ help କରିବାଟା
what is it
21 where is that 21 some statements are there?
miscase number ଲେଖା ହେଇଛି miscase number 53 of 2023 page 21
record is put up today 22
ଭୁଲ ହେଇଯାଇଛି page marking ଟା
No, you have not filed anything. What is this? Where is that order?
file code
order.
ଏଟା ବୋଧେ ଭୁଲ ହେଇଯାଇଛି
20 ରେ ସରିଛି session judge order 21 ରୁ order of the
You will not give the first order. Against that you file revision. Where is the first order?
Hasn't dates out again.
First STGM order you have to file. Thereafter you went to revision order you have to file. Then you came to this court that you have to file. Nothing.
file ହେଇଛି କିନ୍ତୁ
And how will I
ଆଗ ପଛ
dictate an order?
ଆଗ ପଛ ହେଇଯାଇଛି
କାଇଁ ସେ order ନାହିଁ ଦେଖନ୍ତୁ ସେ order ହିଁ file କରୁନାହାନ୍ତି ଆପଣ. Don't waste time. It is already 4 o'clock and we have not reached the middle of see the crowd.
day after tomorrow I will
Day after tomorrow may not be possible. Vacation.
71.
File all the documents. I could have allowed your petition straight away.
May I please, your lords? The petitioner challenged the order of convenience
Yes.
taken under section 147, 148, 294, 506, 120B, 307.
Yes. What is the allegation? You tell me.
Actually, there is a order of convenience taken in against 53 person. Out of 53 person, the 25 persons, those are petitioner in this case, challenging the proceeding. Your lordship can see there is no evidence against the present petitioner, and also in 161 statement. Your lordship can see for a moment. Nobody's
Cognizance order, you have.
Your lordship, IFS case is also not made out. In others, this petitioner has been implicated and
File this
charged.
document. Land Council for the petitioner seeks the adjournment to place and record the additional document to substantiate the case. Present.
Your
73.
lordship, file IA of stay of further proceeding.
This the bunch you are giving right now. You expect me to read right now and pass an order. You should have filed this bunch.
Yes.
What is this practice of pulling out papers from your pocket and throwing in the court? Yes.
73.
May I please? Classic case of abuse of the process of law and the misuse of 498A.
Yes.
Here, a divorce, after 14 years after marriage, the husband had to institute for divorce in the year 2023. The wife appeared in that proceeding and thereafter filed one CC case, not even an FIR. And court has taken cognizance.
6 witnesses have been examined, including the complainant under section 202 inquiry by the magistrate. Let those statements be annexed before this. Let those statements be examined by the
Let the records be, let him bring the records on before the court.
I will issue notice. Let us see if anything can be worked out.
Your Lordship.
14 years marriage.
Yes, Your
After
Lordship.
divorce petition is
Your
filed.
Lordship may call for mediation.
We will send. Straight away I'll send to mediation.
Your Lordship may issue notice
That-
and thereafter let the parties appear
Huh.
and thereafter mediation can be.
No, I'll straight away send mediation awaiting report. Let them through mediation. Let them come to this court.
And
When the marriage taken place?
marriage took place in 2009. That's in paragraph 4.
Yes.
4/5/2009.
Marriage between petitioner number 1 and opposite party number
Okay.
had taken place in the year
2009. 4/5/2009.
when you filed the divorce petition.
On 21/3/2023. Paragraph 8.
Due to lack of compatibility, misunderstanding took place between the parties. Therefore, the petitioner filed a divorce petition. Wide
Civil proceeding matrimonial 32 of 2023
On?
in the family court, Jharsuguda. On 21st of March 2023.
2020. Subsequent thereto, the petitioner, the opposite party number 2, initiated the
After appearing in the divorce.
initiated the criminal prosecution by filing 1 CC case number 4 of 2023. Inter alia making various allegations against the petitioner, against the husband and in-laws.
All in one.
Or in-laws. In-laws. Issue notice to opposite party number 2, written notice. Since the dispute is arising out of a matrimonial dispute, I am of the considered view that the parties should explore the possibility of a settlement through mediation. Therefore, the parties are relegated to the High Court mediation cell.
Would your lordship consider the district mediation because the
District
parties are from
mediation, you tell me.
Jharsuguda?
Jharsuguda.
They will have to traverse a lot of distance.
What is the DLS? DLSA, what is that?
DLS,
District
District
Legal Services Authority. Yeah? District Legal Services Authority, Jharsuguda. The what do they say? This coordinator and coordinator. They are also coordinators. The coordinator of the DLSA shall fix a date, intimate this to the concerned party for participating in the mediation process. Awaiting the mediation report, release the matter on circumstances. In the meantime, proceeding in the ICC case number 4 of 2023 will stay. Yes. Further proceeding in ICC case number 7. Yes.
74.
See, I stayed because once it will be precipitate unnecessary. The mediation is
relationship further.
There is no point.
That will break.
May I please,
Yes.
may I please, Your Lordship?
Yes, sir.
that the matter is emanated from proceeding under 33, my lord. The court of the first instance promulgated the conditional order that having been set aside by the next higher forum, my application before your lordships, my lord. The connotation is, my lord, the public nuisance. My lord, any infringement to uses is a nuisance. My humble submission. Having said so, my lord, any infringement to uses is a nuisance. Having said so, my lord, the petitioner was running a shop in a land. We have to sans, my lord, any dispute between the interested parties. My lord, the opposite party number 2-1, my lord.
What is your challenge?
Challenging the denial of the appellate revisional court set aside the order of the first court promulgating the conditional order. My humble submission and infringement issues because they locked up my shop. I was running a shop in a land that is a interested dispute between the other opposite parties, my lord. 1 and 2 with opposite part number 3. 3 is my owner. I was running a shop there. They locked up and obstructed the passage.
Which part of the order is hurting you? Which part of the order is hurting you?
Yes. May I invite lord's kind attention. Page 31. Very concept, paragraph 6, my lord.
Yes.
The learned court has held, my lord, section 133 deals with removal of nuisance. Next, my lord. But he understood in the terms of 263 of IPC, my lord.
Right.
Then, my lord, that nuisance as an offense against the public that causes injury, etc. The court has held it, but then swayed away, saying it is a individual between the individual. My humble submission, shop is a access to the common man for having access to their uses, my lord. That having been disrupted or usurped by the act attributed to the opposite party, my lord, the very connotation derived by the learned court of the second instance.
It says that there is no public nuisance.
He says that there is no, even though there is a public, but it is an individual.
Party, interception.
Individual. My humble submission, the customer were having access to uses to that shop is.
So have you implemented the orders?
Yes, I implemented.
We issue notice.
Yes, my lord.
Issue notice. Yes, next.
75.
That's a short date, my lord.
Short date.
Next, reopening.
Reopening first. 20th or 21st of June. Yes. Yes, sir.
My lord, may I please, my lord?
Yes, sir.
The impugned order is under Annex 2, my lord. Lordship may kindly peruse page 12.
Yes.
The learned magistrate has rejected the complaint petition as per the dictum passed by the Honorable Apex Court in the case of Priyanka Srivastava, stating that there is no affidavit. But Lordship may kindly see my complaint petition. My complaint petition I have annexed at Annexure 1. The relevant page is page 11.
Affidavit is there.
Affidavit is there, my lord.
It is there, man.
And I have given the certified copy to my lordship, my lord. Of the complaint petition.
Petitioner is agreed by the order dated 21/2/2024, passed by learned STJM Jajpur in ICC case number 55 of 2024, whereby the complaint case of the petitioner has been dismissed on the ground that the same is not in compliance with the parameter laid down by the Honorable Supreme Court in
Priyanka Srivastava versus State of UP.
The court below is of the view that as per the law laid down by the Supreme Court in Priyanka Srivastava Supra, the petitioner of the complainant has not filed an affidavit. The petitioner has placed on record let us see the affidavit language.
Yes, sir. Lordship may kindly see page 11. I do hereby solemnly affirm state that
yes. The place on record the copy of the complaint petition, and at the concluding at the end of the complaint petition, the petitioner has filed the affidavit which reads as under. The affidavit may you page 11. Affidavit छोटो लिखा है affidavit. See, just see only affidavit part.
notice, or no?
ना notice
We
दरकार
need
नाही
to issue notice.
ना notice दरकार नाही कारण
ତାକୁ ତ notice ହେଇନି ସେଠି
ହଁ
ଆପଣ minute.
ତାକୁ ତ ସେ notice ହେଇନି ନା it is expert order
Notice may be issued.
ନାଇଁ notice why?
କଣ ପାଇଁ?
Because see, the complaint case, notice was not issued by there also.
yes
But my only issue is whether the LCR has this affidavit or not, that has to be verified.
I have given the certified copy
My lord, why should we disbelieve the order of the judicial magistrate, my lord?
I have given the certified copy
My lord, Priyanka Srivastava case, my lord, the manner of the affidavit, my lord, that has been, my lord,
Chalo, there is something issue notice.
issue notice.
Issue notice. Huh? Issue notice.
Then which manner the affidavit should be given, my lord?
That is there, but
Not generally, my lord.
but in many cases, this line is important.
My lord.
Affirmed and stated, and the facts stated above are true to my knowledge.
yes
That sentence is required.
yes
He has said that.
that is between
In
the
fact, this is no way of filing
My
affidavit,
lord.
according to me.
Proper affidavit is required, my lord.
He will support, and he knows the affidavit which we
My
used to
lord.
file is complaint and separate affidavit.
separate.
Or that is it. Our High Court.
That
my
was
lord,
the
recently-
idea, but
No, recently our High Court, my lord, affidavit changed, my lord.
That is as per the High Court rule that is that
but
is not
this is
applicable to the
in fact, it's kind of a verification.
My lord,
Yes.
in the
Affidavit
Priyanka,
should have been
my lord,
separately, and in the affidavit there should be a verification.
my lord, in the Priyanka Srivastava specific, my lord, the paragraph taken by about
Anyway, issue notice.
if lordship will lordship can dispose it of na stay এটা dismiss is stay কোন হবে
Mistake is not.
if lordship will be kind enough to dispose it of ticket
Why to get into? I'll issue notice, let him
Ah,
come.
ସେ ଆସନ୍ତୁ ସେ କହିବେ।
Two purpose will be solved.
Man,
If the complainant comes here,
dispose of it,
service will be easy for him there also.
No, my lord.
Dispose of it.
what I am proposing my lord if my lordship will dispose it of granting liberty to the petitioner to file a fresh complaint along with a freshly compliant affidavit and it will be accepted by the magistrate
Right.
that will
That's good idea.
କାହିଁ ପକେଇ ରଖିବ
No, affidavit. Perusal of the affidavit indicates that though the petitioner has filed an affidavit, but the affidavit is not happily worded. At this stage, Mr. At this stage, simply at this stage, then counsel the petitioner submits that he would file a better affidavit before the court below, and
along with a fresh complaint petition along with a
along with the fresh complaint, and pray for issuance of summons to pray before the court to
register to send it
deal the complaint in accordance with the law.
156.3
With this liberty, the petition is disposed of, and the order dated so and so, order dated 21/2/2024, passed by SDGM Jajpur is quashed.
Right. Obvious.
You file a better affidavit. Why?
Yes, yes.
76.
Yes.
May I please, your lordship?
Yes. Yes, sir.
Sir, I filed this CRLC petition for a direction to learned family court for a targeted trial of the maintenance proceeding under section CRPC 125, which is pending before the learned family court 2 since 2018.
You are appearing in person.
Yes, ma'am.
You are a doctor.
No, sir, I'm an assistant professor.
A matrimonial dispute.
Yes, ma'am.
Why are you not concentrating in your profession?
My lord,
Settle the dispute. Why, if both of you can't?
the other side is
I will issue notice. I'll set thereafter. I'll see. Okay. You settle the dispute. It's better.
my lord, if some direction may be given for expeditious trial by the family court 2.
Why to aggravate it?
But I've also filed a matter in which notice has been issued.
Your divorce. You got the divorce.
No, petitioner has filed for divorce, but the petitioner did not appear and adduce evidence. As a result, the divorce petition of my wife was dismissed for default. And I had also filed a counterclaim for divorce. So the family court 2 also did not accept my counterclaim. So for acceptance of my counterclaim, I filed a matter in which notice has been issued to my wife.
In this case, you filed some 340 application.
Yes, my lord. I have also filed a 340 application because my a wife is a software engineer, and by suppressing facts, she has suppressed the fact before the family court too, and she is dragging this litigation endlessly only to harass me. And I've also raised this issue many times before the learned court family court too, but the learned court family court too is not taking any action.
No, anyway, I'll issue notice to your wife. Issue notice. Immediately after vacation. Letter come.
77.
Short date.
Short date means immediately after vacation.
Here, my lord, the offense under section 138 NA Act 205 application is rejected. Against that, my lord, I have filed this application. The amount is very low, my lord. I am also trying to settle the dispute.
How much?
2,75,000.
Pay it and
My lord, I am trying, my lord, because some financial problem is there, my lord. That's why he could not pay, my lord. For which, my lord, he filed the application. My lord, done some time, my lord, so that
simply issue notice letter.
issue notice and no coercive action.
No,
NBW issued, my lord.
NBW, you appear, I'll pass the.
My lord, if I will appear, then definitely will remand.
138, sir.
My lord, 138.
They'll take you, hang you also.
Kept in abeyance till 2 months or 1 month.
Why?
Till I will arrange
138 proceedings should have been concluded within 6 months.
My lord,
You are accused.
My lord.
You are buying time.
My lord, I am arranging money, my lord, to pay my lord.
Arrange money and come tomorrow, I'll take it up.
Tomorrow, my lord, it is not possible.
Deposit 20%, I'll stay.
20%, my lord. 20,000 I will deposit in.
What 20,000?
20,000 your lordship.
Simply issue notice.
Oh, small amount, my lord, your lordship. NBW, my lord, otherwise, my lord.
NBW, I will just, where is that NBW order?
My lord, NBW order, I have
page 16.
Page 3, my
Put up
lord.
on 20th May for production.
In the IA, my lord, I have enclosed, my lord, stated, my lord. In IA, my lord.
I should have dismissed the petition right away for the reason that the complaint case is initiated in 2017.
My lord?
2017.
My lord, 2000.
You are the accused.
My lord,
2 lakh rupees check you have given.
My lord, he has not.
2017 to today, how many years?
Already, he has not.
7 years.
My lord, recently.
And what the statute says?
My lord, recently he came to know that after my lord, NBW, he came to know. Thereafter, he filed the application.
You have not filed the NBW order also.
No, my lord.
Where is that NBW order?
NBW order, my lord, I have not filed, but I have mentioned in paragraph 3 of my IA, my lord.
But page 16, it is listed on 20th of May for production of accused.
Production of
page
accused.
16.
That is the order, my lord. That's why, my lord, they rejected the application.
Where have you said?
Paragraph 3, my lord, of my IA, my lord.
Paragraph 3.
3, my lord. Page 2, that the London Magistrate by the order dated 9/8/23 NBW
Issue notice to opposite party number 2. In the meantime, the learned counsel petition submits that the NBW for the magistrate, the court below has issued NBW against him by the order dated 9/8/2023. Next date of hearing?
20th May, 24.
Learned counsel for the petition submits that he declined to appear on the next date of hearing, that is 20th May. And seek appropriate remedy under law. Under law. You go on appeal.
78.
May please, your lords. Sir, I may be permitted to move on behalf of Mr. Rocco, my lord. Here in this case, my lord, the offense under section 341, 294, 352, 354, and 25 Arms Act, my lord. And your lordships may kindly see, in the meanwhile, the matter has been settled between the parties, my lord. The matter has been settled between the parties.
Yes.
He has annexed the compromise petition is annexed 2, and thereafter, my lord, he has also the informant has also filed affidavit stating that he was not interested to proceed with the case.
Bring them.
Insofar as the offences under the Arms Act and the Explosives Act are concerned, these are heinous offences.
In this case,
He has brandished a gun and he has also thrown a bomb. He has tried to throw a bomb into
he
the
was thrown, my lord, and he has tried to throw. This is the allegation, my lord.
Tried to throw only,
Those are
therefore
offences against
nobody has
public order.
died.
If
you have thrown,
ଖାଲି ଗୋଟେ ଅଫେନ୍ସ କରିବା ପାଇଁ ଆଜ୍ଞା, your lordship vast experience
it was recovered from you.
କିଛି ରିକଭର ବି କିଛି ନାହିଁ ଆଜ୍ଞା.
What is recovered?
Well, none of the other documents are annexed, my lord, I'll call for the.
What is recovered from?
Recovered from him, nothing has been recovered, man. If your lordship is not inclined, other co-accused person,
25, 27.
other co-accused person has been released on bail, man.
Bail is something different. You.
If your lordship is not first or second parent, your lordship. Same day disposal.
Since you have said that it's compromised, you bring them, I'll watch it.
Till then, no correction, man. Next Monday, go assume. Till then, no correction.
When was the FIR?
FIR is
March.
March.
Till March, nothing happened. Within 2 days.
नहीं पुलिस अरेस्ट करलानी अभी 3 जन पूरा 3 जन अरेस्ट करे बेल गलु नहीं
नहीं
जोड़े आगे अच्छी खाली नोट 8 दिन पे
You have not filed anything. How will I arrive at it?
ए किछि और नहीं पूरा खाली एफआईआर होता इन्वेस्टिगेशन चलछि राइट
The CD has not come. The fresh matter, man.
CD
The FIR it is clearly mentioned. mo mundore bandhuk lagai mote.
ता पर से सेटलमेंट कर सालानी
Settlement को.
Dispute आगे तांको जमी बट dispute होची for that जाके एफआईआर करछोंदी
But see the offenses, allegations are key.
yes like consider that
And you kill someone, thereafter you will say that I settled.
ताया किल फिल किछि ना सेकर बदो कहि जे नो नो गन नो बम
That is what I want to know, whether it is anything recovered or not from
ते
you.
सेटा आगे
Bomb
बर्तन
is recovered or
that will not give to us बर्तन आगे से केवल आनी परिबे सीडी डालले they can bring the CD man
Monday le बात
till then no correction yeah सोमवार पर्यंत
no question. It is not. Don't convert to 482.
same day disposal कोई की सब गले नहीं
See, these are not bail applications, sir. This is 482. You said that it's settled. Therefore, I am trying to examine whether it can be washed or not. Yes. 79.
the lordship issued notice to the appointed party man because he is a magistrate पाखा जाय करछि affidavit
You bring them. You have settled. Bring them. By the time he'll get it, and we'll pass it. Yes. 79. None appears.
May I please, your lordship?
Yes.
My lord, this is a bail jump matter.
Okay.
My lord, petitioner was granted bail on 6/1/2020 and NBW was issued on 6/3/2023, my lord.
500. Yes. Next. 80. Carefully write down. Yes.
May please, bail jump matter.
Yes. Or no, just check it up.
Yes, ma'am. 26th of September 2016 is bail, and NBW is on 6th of March 24.
24. 500. Bail. You tell once again. Repeat the dates.
26th of September 2016 is bail, and 6th of March 24 is NBW.
500. Yes.
81. Not 6th or 29th of 23 on NBW was issued. In item number 80, NBW was issued on 22 of 9, 2023.
Be sure about what you are saying. 1 minute.
At page 30.
22.
22 September 2020.
22 September 22.
The last, thereafter it has been issued afresh on 6th of March 24. That is the last order.
That is last order. He's correct there.
That is
Yes.
the first NBW list.
81.
Bail jump matter, my lord. He was on bail on 11/5/2010 and NBW was issued on 17/4/2023.
500. Yes.
Obviously.
82.
Belgium matter, my lord. NBW order dated 5/5/2011, my lord. Petitioner was on bail earlier, my lord.
Was on bail.
Belgium matter, my lord.
Was he in bail? When he was on
Bail on 30th of September 2010.
Okay. NBW on
5/5/11.
5/5/11. Oh, 1000. Yes. 83.
16/12/2022. NBW was issued. 16/12/2022. 16/12/2022. Bail में 205 allow हुई था 130 next.
133. He was when his application of the section 205 was allowed. The petitioner is an accused in a complaint case under section 130.
Right.
NBW issued on 16/12/2022 during absence. Yes. 84.
Belgium, order dated 17/4/2023, was on bail on 1/7/2016. No. 500. Okay.
85. Belgian matrimonial order dated 27/2/2024, page 9, my lord.
Bail.
Bail, my lord, 18/12/2015, my lord.
15.
18/12/2015.
86. Belgium matrimonial NBW issued on 15/4/2024. I was on bail, but specific date is not. Specific date and I bail.
They were on bail. 3 of you are there.
Well,
3 of you are the bail. NBW issued on
15/4/24.
1,000. 3 of 1,000.
1,000. Hon'Ble.
87.
My lord, Belgium matter, bail on 24/6/2016 and bail jumped on 9/1/2024, my lord.
2024.
9/1/2024, my lord.
500.
Oh, only, my lord, 4 petitioner, they are 1 family member, 1,000 all
1,000 total.
all total.
88.
88, madam. My lord, Belgium matter, order dated 3 January 2024. Bail was issued by this honorable court on 1/11/2021.
500.
Page number 10 and last page number 16.
500.
89.
Belgium matter, NBW issued 1/7/23. Bail was granted 17/3/22.
22.
My lord.
500.
90.
90, my lord. So modification of order dated 34/2024, my lord. Para 1, 5th line, my lord. So the date is 5/4. It should be 10/4, my lord.
5/4.
Para 1, 5th line, my lord.
Para 1 re 5/4/2024 ଅଛି, 10/4/2024. But that's all.
Yes, my lord.
ठीक है जी. Order dated 30/4/2024 ର. Para 1 ରେ ଅଛି 5/4/2024 ଟା ଆଉ 10/4. Yes. Next.
91.
91.
General here.
None PS.
4% 5 supply 5 rate ऊपर आएगा. Bail granted by the magistrate, my lord, not a magistrate. He has to file the application for 37 supply 5 there instead of filing there, my lord.
92. Shall I dispose of?
92, may I please your lordship. Here, my lord, I have filed this application challenging the, my lord, order of the Lord and Appellate Forum, the White Annexer, my lord, to that I have filed the bail application before the Honorable District and Session Judge, who is the Appellate Forum. Fact of the case, my lord, that these present petitioners, they face the trial before Assistant Session Judge Potamundi. And then, my lord, during trial, they were convicted for the offense under section 306/34 of the IPC. That 4 years and that fine amount convicted, my lord. Thereafter, my lord, they prefer an appeal before the District and Session Judge Kendrapada. And my lord, in appeal, they have also preferred an application for bail.
389.
Yes, my lord, bail. And this bail application was rejected. And challenging that bail application, I have before your lordship. Sentence, my lord, that 4 years, my lord, sentence. Out of, my lord, 4 years, my lord, that this present petitioner was in custody since, my lord, 28/8/2022. Now, my lord, more than 2 years I am in custody. They are in custody.
Yes.
Out of 4 years, my lord. I have
Custody 1 year, 3 months, so now 6 months. 6 months, my lord.
Right. Petitioner has been convicted by which petitioner is accused in FIR number 1. After he faced the trial and he was convicted by
the assistant
Where is
session
that
judge-
order?
That annexer 1, my lord, order judgment copy, my lord, I have annexed.
Annexure 1.
I get.
White order dated where is that?
Judgment.
No. White order dated 14/12/2023. In sessions ST case number 296 of 2022, the assistant session judge Putamundai convicted the petitioner for offense under section 306.
306, read with
34 of the IPC.
34 IPC and sentence to undergo
My lord,
substantive sentence of
4 years
4 years
and to pay a fine of rupees 10,000 in default undergo RI for 1 month for the offence under section 306 34 of the IPC.
Okay.
Aye.
Petitioner preferred an appeal before the sessions court. Where is that?
That, my lord, I have preferred the appeal, my lord, before the session judge, my lord. I have annexed.
Petitioner preferred appeal, criminal appeal number 3 of 2024 before the sessions court Kendrapada, assailing the conviction and sentence passed by the court of sessions Kottaman. Although the appeal was admitted by the appellate court, however, his application under section 389 CRPC has been rejected. Therefore, he is before this court. Let counsel for the petition submit that the petitioner has already undergone.
My lord, I am in custody since
Petitioner is in custody since
28/8/2022.
28/22. Kete learning about
by things.
1 year, 3 months judgment board. 6 months. 1 year, 3 months and 16 days. Now 6 months.
Taking into consideration the petitioner has already undergone about 2 years of sentence. I am of the considered view that petitioner is entitled for grant of bail. Therefore, the appellate court is directed to release the petitioner on bail on the condition that granted bail allowed.
Oh, bless you. My lord, ST case dita podichi. ST case number 133 of 2022. Tapare sessions court.
I may be excused, my lord. 91.
91?
But that is my lord a cancellation bill. 437 subclause 5 grade.
You
Say correct. Say the observation.
Let counsel for the petitioner seeks to withdraw the present petition to avail the remedy under section 437
clause 5.
Clause 5 CRPC before the court below. The petition is disposed of with the aforesaid liberty. Yes.
Oh, bless you.
91. Yes. Yes.
93. Lordship, on behalf of Mr. S.S. Mahapatra, can you take note 2 more years?
Adjourned. Yes.
94.
94. I prefer
After vacation.
vacation.
Miles.
Notice could not be issued. You have to take it.
Today we have filed the reply. Here is the slip.
That he has filed the requisites today for serving the notice on opposite party number 2. Adjourned. Yes.
95.
Not seeking for an adjournment. We'll send the notice on the same address.
Adjourned.
96.
Yes. None appears. Adjourned.
98.
Order of convenience is under challenge, madam. Here the background of the case that on the basis of the affair, the investigation was taken up. And while the investigation was continuing, on the strength of that decision of the Alok Jana versus State of Orissa and Honorable Supreme Court decision, the matter investigation was taken up by the CBI. During investigation by the CBI, the managing director of the company, namely Durga Prasad Mishra, he was arrested and faced the trial. And after conclusion of the trial, he was convicted, and he has served the sentence for 3 years. So, but after that case also, the present petitioner who was working as a manager of that company, he was arrested, and against him cognizance has been taken.
What is wrong?
Well,
what is wrong in it?
But here that particular case was proved against that managing director, and the managing director was convicted. That particular incident. Thereafter, because initially the case was registered against the present petitioner and some others.
You must be absconding.
Yes, I was absconding, but that subsequently I was arrested. I have been released on bail by virtue of the order passed by this
Charge sheet was filed against you.
Charge sheet was
You were
filed against
absconding. And the other accused has faced the trial, he got acquitted, whatever.
No, the charge sheet was filed showing me after my arrest. After my arrest.
Thereafter you evaporated.
No.
Then why the trial could not proceed against you? That's the only reason.
No, the CBI people has not arrested the petitioner. After the investigation, perhaps I am not convinced, Your Lordship. Initially, the FIR was lodged at the Ali police station against the present petitioner. At that time, petitioner was not there because petitioner was absconding or the police could not arrest him. In the meantime, on the basis of the direction of the Honorable Supreme Court,
it is transferred to CBI.
And the CBI people, they investigated and they took that managing director into tax and arrested, and thereafter that Durga Prasad Mishra, he faced the trial, and after conclusion of the trial, he was been convicted. There is no material against the present petitioner that he was a part of that crime. But on the basis that the initial FIR was there against me, and the investigation was continuing, I was again arrested. Even after
Arrested by CBI.
Arrested by the CBI.
Where is CBI is not a party here.
That mistake, Mr. Because it is not originally, I was not.
That's the major mistake. Right on. Mr. Mahapatra seeks leave of this court to implead CBI as a party to this proceeding. He may do so within a week. Again, next. Yes.
99. May I please, Lordship? I'm challenging the quashing of FIR, my lord. I'm concerned to the clear, my lord, one-day disposal of the one-day disposal of the petition.
2023, what is early?
One-day disposal, my lord.
What one-day disposal?
Earlier, this petitioner, my lord, he has filed a serial MC for the quashing of FIR, my lord. But under the section 381, my lord. And earlier, this petitioner has obtained the anticipatory bail surrender within 3 weeks of and disposed according to the law.
Okay, you have filed an appeal against that order, anticipatory bail.
No, my
you
lord.
want variation of that order by in the 482.
This is the main. This is not a main accused.
You have come to a wrong court. You have to go to Supreme Court for that. You have got bail, wrong or right, there is a bail order.
Yes.
How can I modify that order?
I'm saying, has the main accused has been released on bail, my lord? This is a wife of the.
I don't know. What is your prayer here?
Quashing of the FIR, my lord.
Quashing the affair. Investigation is going on. I will not interfere.
My lord, if in FIR, my lord, the name of the petitioners doesn't reflect in the FIR, my lord. Subsequently, as the ornaments has been seized from the house of the petitioners, my lord, they have added an accused person in this case, my lord.
The FIR was the petitioner is an accused in the FIR, PS case number so and so, or dated FIR number 6/2/2023. Investigation is still going on. At this stage, petitioner has filed the present petition seeking quashing of the FIR. I'm not inclined to interfere in this matter. However, liberty is granted to the petitioner to approach this court if after the charge sheet is filed, if the cause of action still survives. Yes, next. Next.
101.
Hey, my lord. May I please, your lordship?
Yes.
There is a defect, my lord. So I may be allowed one more time, my lord, for removal of defect, my lord.
Cure the defect. Yes. Next.
108.
108.
354, 506, 3 SST, compromise matter.
None appears. Adjourned.
109.
109, may I please, my lords?
Yes.
My lord, on behalf of Mr. Ramdas Achari,
Yes, yes. Sir.
my lord, there are defects, my lord. I may
Defect?
be pardoned for that. There are defects.
Cure the defects.
Obliged, my lord.
Yes.
110.
None appears. Defect, or EC is pointed of defect, one will time you grant it. Cure the defect. Yes.
112.
My lord, kindly be taken up the matter after vacation.
Very good. After vacation, cure the defect.
Oh.
Defect, there are defects here.